Mr. Little on the bus with a battery to spare. Bike parked in the aisle, oh, he didn't care. Lady driver asked him to kindly alight, shook his head and said, not without a fight. Oh, Mr. Little, you're a stubborn kind of guy, holding to your battery, waving civil rights high. Bus is late, but you don't seem to mind, making a scene while time falls behind.
All right, welcome back to the Court of Public Opinion. I'm going to turn that one down. That was version 2. It wasn't quite as good as the old one. We are back. People are, I think, coming in. Let's see if it is it working here. It shows we're on air. All right, we are back. We're back. All right, wonderful. I didn't play the normal music. I will congratulate, though, however, Greeners. Oops, if I hit the right button, that'll work better. Greeners, who was first in chat. Congratulations, Greeners. The internet is all yours. We are going to continue right where we left off in this trial out in Thurston County, Washington, knowing that we're watching court, and we're also on verdict watch in the trial in Florida with Collin Griffith, who's charged with murder and kidnapping his mom. So we will interrupt whatever happens here with that. But right now we're going to pick up right where we left off. We just want to give people a couple minutes to come in. Looks like some people are filing in. We'll give them just a second to get in here, as Ms. Rowe is still questioning the first witness that the state has presented. This is the supervisor of the bus company. I realize this is not a high crime type trial. This is unlawful behavior on a bus, disorderly conduct type issue. But the defendant is adamant that it did not happen. His civil rights are being violated, and the state is going to, or the city is going to prosecute this one to the fullest extent of the law. And we're here for it. Thurston, Washington delivers once again. So let's go ahead and continue where we left off with Ms. Rowe asking questions of the supervisor on the stand.
Do you remember watching Mr. Little take out his headphones and answer her question? Yes or no?
I don't specifically remember that. I remember the part about asking
just
about
yes
a battery.
or no?
I love the yes or no.
You don't remember him responding?
No, what I was saying is I remember the part about asking about the battery, because that's what this whole situation is based on. I don't remember the specifics of what was said or who did what 8 months ago.
But you viewed her asking Mr. Little about the battery.
I did. That was the whole basis of the video.
And Mr. Little responded, yes or no?
Yeah. I don't remember what he said specifically.
Not asking you what he said, asking whether or not he responded. Then you viewed the bus driver taking off and going about her route, correct?
Yes.
And you viewed the route going on without incident.
Incorrect.
I didn't finish my question.
Well, there was another incident, so it's an incorrect statement.
What was the other incident?
So the operator had shut their back door a little bit too early, which happens at times because not always the mirror angles aren't always perfect. And somebody's arm was in the door, and Mr. Little was yelling up at the driver about that, harassing her about closing the door too early, which also escalated the situation further.
You slammed the door on a rider's arm?
So.
Okay, now you have reason to yell at the bus driver.
The driver closing the door on a passenger that was getting off the bus. Yes or no?
Yes.
That could be fatal.
And immediately thereafter, you viewed Mr. Little telling the bus driver that she shut the lady's arm in the door. Yes or no?
Objection, facts not in evidence. There's no evidence to support that it was immediately after.
Okay. I'm going to sustain the objection. We're going to take a break. You folks are going to go back to the jury room. And then I'm not sure how long this break is going to be, but then we'll be back in session in a few minutes.
Okay, jury leaves once again. The second time they've been kicked out of the room for what we think is a sidebar. The witness is also going to be kicked out. Ms. Rowe dragging the truth out of the bus supervisor that the bus driver slammed the door on someone who was exiting the bus before they had exited the bus. And that might be why.
Just with regard to this line of questioning and cross-examination, this particular witness's opinion, what's in the video, really, you can be seated, really doesn't matter. I mean, I'm told that the jury's going to see this video and they can make what they want, but this witness's opinion of what he saw I don't, it's not really relevant as to what this person observed on the witness, particularly when the jury's going to see the video. And then you can make whatever argument you feel is appropriate based on what the video shows and what your take on it is. I'm sure I'll hear Mr. Thompson's take, and then we'll go from there. But I'm gonna again I don't. This witness's opinion of what was on the video, go through, well, you saw this, and then you saw that, and you saw that. I don't think it's relevant to the ultimate issue in this case. And so again, I'm just going to ask you to move on.
Okay, Your Honor, I understand. In response to that, Your Honor, just so I'm perfecting the record, my line of questioning was simply to ask, to clarify what Mr. Rose viewed.
Right. And the jury will see what he viewed. And they know he viewed it. And then you can put whatever spin on that that you wish to. And so I suspect someone's going to request to use the restroom, which I will allow. Maybe not.
Nobody needs.
Do you have an idea for how much longer do you think you will go?
Not very much longer.
My redirect will be less than 5 minutes, Your Honor.
Could you reduce that to a number in terms of time? Mr. Thompson just told me he had less than 5 minutes.
I probably have less than 5 minutes also, Your Honor.
All right. You spent, it's now
I probably only have 3 questions.
11:25. You have another witness here. I'd like to get started with that.
No, Your Honor, we're not calling him.
You're not calling in?
No, we're
Okay.
not.
Fair enough.
So is this the only witness the prosecution has? Is the bus supervisor? Not calling the police officer?
Yeah. Do you need to use the restroom, Mr. Wolf?
No.
Okay. All right.
Tell me, go before you go.
I'll be fine. I can hold it.
it.
I can hold it.
Just talking for a long time can get pretty parched.
Yeah, I know.
We're all a little
What are you
parched
saying?
listening to this.
Been known to go through
Maybe on
6
the back
cups
of
of coffee
here.
during a
Yeah,
trial.
yeah.
Oh my goodness.
6 cups of coffee during a trial. Can you imagine him questioning a witness? After 6 cups of coffee. Wow. They're not calling the bus driver. She was really shook up. That's probably better. I would hate to see her having to relive that. She's probably very self-conscious about slamming the door on a
You
passenger.
wrote on the back of one of those pages.
Okay, so we're on the record. The recording hasn't stopped, so I just want everybody to be aware of that.
What do you guys think? Is the jury going to say it's a civil right to ride the bus with your car battery? They heard that the bus driver slammed the door on a passenger's arm. Mr. Little probably yelled at her for that. Like, hey, what kind of driver are you? She hadn't got off the bus yet. And then the bus driver retaliates, like, "You car battery person, off the bus," and he wouldn't get off. He's like, "What did I do wrong?" I can see this. I can see this happening. I hope this is exactly what happens on the video.
Go ahead and bring him back in.
I would say slammed. Usually the bus doors are not, they're not manual anymore. It's not like you're pulling a lever and there's a relational amount of movement directly connected to how far you pulled the lever. Usually you push the button and the doors go and close. So slam and slam. It's not like you're like, wham, take that. But it's subjective slam. Well, I'm going to go with slam. The doors slam shut. They slam shut when I'm late for the bus, running for it, and the doors close.
Ms. Rowe, you may continue.
The jury is back. Here we go. See if she has any more questions.
So you indicated that there was a second incident of communication between Mr. Little and the driver. Is that correct?
Yes.
And that was the incident connected to the driver shutting a passenger arm in the door.
Yes.
This is good work for defense.
And you indicated that Mr. Little informed the driver that she had shut the passenger's arm in the door, correct?
Yes.
What was the driver's response?
Objection calls for hearsay.
Sustained.
You can ask that differently. Without asking for what she said.
Did you investigate the bus driver's actions?
And Your Honor, objection at this time. These are not relevant to Mr. Little's trial.
Sustained on the basis of relevance.
And those two incidents of communication between the bus driver and Mr. Little were the incidents that you responded to that day?
Yes.
She wants to be his civil rights attorney. Okay. Let's be done with this witness. And let's have Mr. Little take the stand, please.
Any other? Make sure.
He wants to ask a bunch of civil rights issues. The lawyer knows that they're not allowed, although she tries.
Now, back to the recordings that are taken on the bus. The bus has cameras inside the bus.
Yes.
Are there cameras outside the bus?
Yes.
Are there microphones that pick up sound on the cameras that are inside the bus?
Yes.
So they show video and record
Audio.
what's said.
They sure do.
He's like, play it. Play it. I dare you. It's going to be good. Hopefully we get to hear.
Do the cameras that are on the outside of the bus, do they have video and also record sound?
I don't think the outside cameras record audio,
That's the word you were looking for. Audio.
but they typically will pick up, if the doors are open, the interior audio a lot of times will pick up stuff outside of the bus.
Night. That's funny. I hope that's not a thing.
Are you able to access that video, the video, while you're there at the scene?
No.
Now, what would be interesting? The prosecution
So you
has not
called
introduced the video,
for law
right?
enforcement
As evidence.
after Mr. Little refused to be removed from the bus?
I did call for law enforcement to help him get off the bus. I still had every intention of letting him ride the next 12. However, he refused to get off, so he got arrested.
It was route number 12,
So he
not 12
wasn't
buses.
immediately trespassed from getting on another bus?
No.
He was getting removed because he refused to get off the bus when asked to get off the bus.
Why not?
It wasn't my goal to have him not ride the bus. It was my goal to ensure the safety of everybody in the community and the people on the bus, to have that driver be of sound mind and be focused and paying attention to the road. And I could get Ken Little on a different bus that was right behind at that time to get to his destination. So I didn't have the intention of telling him he couldn't ride at all.
That bus driver,
Had he just simply got off the bus
please
and
not
had a
my
conversation with me, he would know that.
I actually like Miss Rowe. She's fun to watch, even though she's got a very unique and slow style.
Do you know who prepared the video of the incident that you watched?
I believe my dispatcher, Chad, started the video in our system.
Let's get Chad in here for chain of custody.
And when I say dispatch, dispatchers are also supervisors. We bid those jobs, road or dispatch. It's the same title.
Should put Chad in
Is
the
that
song.
video edited in any sort of way?
Only the start and end times. But I don't believe, whenever we start it, if somebody reports an incident to try and capture the whole event, we will go back 5 to 10 minutes on each end so that we capture the whole thing, because we want to make sure that we get everything. Obviously, when we're not there, we don't know the exact time something starts and something ends. If we cut a video and it's missing a piece, we'll just redo it and go back even farther till we find everything.
So they don't edit the middle. They just choose the start point and the stop point.
Hold on.
She's well over her 5 minutes and taken most of the prosecutor's 5 minutes as well.
Now, you wrote a statement for the Tumwater Police regarding this incident, did you not?
Yes, they asked me to.
Do you remember what you wrote in your statement?
I do not.
I can't believe we're approaching the 3-hour mark on deliberations.
If I were to show you your statement, do you think that you could use that to refresh your memory?
You have to ask a question first.
Objection, Your Honor. There's no question before the witness.
The question was, if he were to see a copy of his statement.
So he earlier indicated that he did not remember. So now she's asking if she see a copy of it. So I'm going to overrule the objection and allow the answer.
Do you believe if you saw a copy of your statement, it would refresh your memory?
Sure.
Yes.
That needs to be marked as an exhibit, Ms.
It's
Rowe.
hostile.
I will.
No truth to the matter that she wears sweatpants to court. Those are not sweatpants. She did win one. This is key, especially if something he put in his report to the police is a little different than how he told the story today. Impeach the state's only witness. That's good defense work right there. I'm sure she didn't mean 50 minutes. Oh. Thank you for the likes on the channel. We were already at 399 likes. 401 now. Thank you. Thank you. Appreciate that. You have to show it to the defense.
Defense exhibit number 1.
Okay.
If you could take a look at that.
Get an idea of where the witness is seated based on how she just walked up and handed him the paper. The judge is actually seated sort of in the bottom left-hand corner,
Do you
just off the
remember
screen.
writing the statement?
I do.
If I could have that real quick.
You want me to finish reading it or?
At first, I really just wanted you to identify that.
Yes, I do know that I wrote the statement.
The
Yes.
statement that you wrote.
Yes, that is definitely what I wrote.
This is good. I want to see where she goes with this. Well over time.
If I could bring your attention.
Ms. Rowe, if you could stand with this podium so Mr. Little can hear, please. Thank you.
I'm sorry, Mr. Miller. If I could, I would like to
No, I don't think it's sweatpants. They have racing stripes.
if I could have you
They're slacks.
review the first 3 sentences of your report.
There are going to be objections here. Watch the prosecutor waiting for the chance to pounce here. He doesn't want the report read.
Do you see anything in this statement that you would want to change or clarify?
Okay, Ms. Rowe, I would have you remove yourself from the witness, go back to the podium, please, rather than just stand there.
I don't, in the first 3 sentences, see anything I would change. I wrote down what the operator stated.
And what did
Time
the
out of
operator
dispatch.
state?
Objection, hearsay, Your Honor.
Seriously.
Okay, I'm going to overrule the objection. You can, there's been a lot of testimony about this, and he written his statement time, and so I'm going to allow him to answer.
The operator stated she asked what was on a passenger's bike, concerned it may be a battery, which intercity transit does not transport. She stated he refused to answer the question and started yelling, that she was violating his rights and being aggressive.
Okay, thank you. So in this statement, you indicated that
Girl,
the
welcome.
bus driver asked Mr. Little about the battery or what she believed to be a battery on his bike.
Mhm.
And in your statement, you also indicate that she told you he refused to answer that.
That is what she said, yes.
Does that comport to what you viewed?
Objection calls for a conclusion.
She said, well, I'm going to wait for the court's ruling.
I'm going to sustain the objection.
She told you she asked him a question and he refused to answer.
Objection, again, hearsay.
It,
Okay, so that's already been asked and answered. He read what was in the statement. Is that correct? Are you just asking him to repeat what he just said?
I'm asking him
So ask him to
to,
confirm the events.
yes, repeat what he said, Your
And
Honor.
I'm going to sustain the objection on the basis it's been asked and answered.
Understood, Your Honor.
Judge is also giving Law 101 classes today. She wants to say, did the video support what that statement was from the bus driver? And I'm betting it didn't.
Don't believe I have any further questions
Mr.
for
Thompson,
this
you
witness.
Thank you, Your Honor. I'll keep it brief.
That was at least 10 minutes.
Mr. Rose, previously you testified some of the rules. You try to list a number of rules off the top of your head, and obviously there's a laundry list there. Is one of the rules not following bus operators and transit employees' directions and orders?
Yes.
Objection, Your Honor.
On what basis?
Hurts our case.
I think you had asked him about the rules. And I think Mr. Thompson is following up on one of your questions on cross-examination. So I'm going to overrule the objection and allow him to answer.
Again, I'll ask, is one of the rules that passengers need to follow directions of bus operators and transit employees?
Yes.
And there's been some discussion about batteries. And I want to make sure it wasn't lost. The bus driver's concern was regarding the potential for a battery on Mr. Little's bike.
Yes.
And you guys can't transport batteries.
Yes.
No.
So she was trying to ascertain whether or not the object on his bike was in fact a battery.
She was doing her job.
Okay. And again, I'll keep this brief, but you said you would have offered Mr. Little a courtesy ride as one of your de-escalation tactics, correct?
Yes.
What is another de-escalation tactic that you often use?
The other one that I mainly use is to offer, if they're acting unruly or misbehaving or breaking one of intercity transit's policies, instead of telling them they can't ride for the day, I typically try to meet them in the middle and say, hey, just step off of this bus and we can get you on the next one.
Okay.
Which is what I attempted to do.
So when you respond to a bus, you're not there to conduct a full, thorough investigation of the actual incident, correct?
Right. I can't do that. I don't have access to the video or any of that. It's a he said, she said thing, and I have to make a judgment call.
With respect to these situations, what's your, I guess, primary overall concern?
Safety.
And safety, is that an effort to get the buses moving again?
And get those fares
not
coming
necessarily. If it's not safe for the bus to continue, then sometimes it will sit. But yeah.
So when you respond to a scene, it's not to determine who was right and who was wrong, but simply to make sure the situation's safe and so the buses can operate. Is that a fair assessment?
Yes.
Okay. And when you responded, you said about 20 minutes talking with Mr. Little, trying to get him off that bus and onto the next one.
Me and the police, yes. We spent a fair amount of time attempting that.
And you were still writing that one-page statement when the next number 12 arrived.
Yes.
That's an answer. Thank you. No further questions.
Ms. Rowe, any cross-examination on or recross-examination on Mr. Thompson's questions?
Yes. What is your understanding?
This will be objected. Did they open the door? Don't think so.
What is your understanding of the rule you're referencing that orders passengers to follow transit authority orders?
It's the transit guidelines. It's on the pamphlet.
Transit policy. So if an operator asks somebody to get off the bus because they are sleeping or eating or sitting with their legs up on the seat, acting in a disrespectful manner, refusing to move out of the ADA area for people in wheelchairs or other mobility devices, things like that.
They've been on the bus too long.
What if a driver orders a person off the bus based on their color?
Objection.
That doesn't happen.
on Rosa Parks commemoration day. That doesn't happen. Seriously. Oh my goodness. I'd like to think it doesn't happen, but wow.
Is Mr. Rose, is sleeping on the bus prohibited?
It is. It's unsafe. If a bus has to make a hard stop or any other maneuver and the person is sleeping, they can fly into the aisle and hurt themselves, or, you know, fly forward if we have to hard brake.
Is it,
How would being awake change that?
Codified by law or by policy?
I can't say by law, by policy, definitely.
Is eating a snack against the rules on the bus?
It is. Eating is against the rules on the bus.
Oh, man. I'm going to do it anyway.
And a person can be removed from a bus for eating a snack?
Typically, we don't do that, but yes, they can. If they refuse to quit and are making a mess and continuing to just eat and not follow the rules of the ride, they're there for a reason.
So is it posted where the general public would have knowledge that a passenger is not allowed to eat a snack on the bus?
Objection, relevance. The rules being posted.
Overruled.
It's posted downtown. It's posted online. Yes, anybody can find the rules of the ride.
Did anyone ever open the box to see if it was a battery?
No, I
Objection,
didn't
relevance.
need to. It was an ammo crate. I know what it was, but the operator didn't. That's why I was trying to explain to Mr. Little the reasoning
was
for
an
her
ammo
questioning
crate.
and
But the conclusion was he was not transporting a battery.
correct.
The lawyer objected. The
I was
witness
able to
overruled.
make that not assumption, but I was able to see that right away. I know what an ammo crate is.
And so, in conclusion,
It's a metal box the military used to store ammunition.
you did just testify that when you arrive on the scene of an incident, because you're not present for the incident while it happens, and because you are not able to immediately access video and basically rewind and see what happened, you have to make a judgment call.
I do.
And on this day, your judgment call was to remove Mr. Little from the bus
Yes.
based on what you believed to be aggressive and harassive behavior.
The way he was acting with me, yes. The operator told me what happened, and when I went back to speak with him, Mr. Little was acting in a manner that led me to believe the operator's statements to be true. So my best judgment call for the safety of everybody was to have him get on the next 12 and have the driver continue on.
Did you happen to ask any of the other two passengers whether Mr. Little's conduct was aggressive or harassing?
Objection, relevant.
Sustained.
So you based your opinion on Mr. Little's being removed from the bus on how your interaction with he and you went when you arrived.
Objection,
Yes.
asked and answered.
It has been, it's been answered again, so I'll overrule the objection.
No further questions, Your Honor.
Mr. Thompson, anything further?
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
You may step down and you're free to go.
Thank you.
All right. Is the
Mr.
state going to
Thompson, do you have
rest?
any further witnesses?
No, Your Honor. The state rests.
The state rests.
So, members of the jury, the state has now rested. And so what's going to happen now? It's about 15 minutes or 10 minutes before our noon break. Mr. Thompson's gone. I'm going to wait till he comes back before I start talking
Because he
again.
just walked out of court while the judge was addressing the Mr. Thompson, paging Mr. Thompson. Mr. Thompson, please return to court. It's in session. He never.
I've released the witness, Your Honor.
What's that?
I've released my
Thank
witness,
you.
Your Honor.
So Ms. Rowe had earlier indicated she was going to give an opening statement at a later time. Now is that time. Ms. Rowe, you have 10 minutes.
Hey, we have something happening in out of Florida. We just had the mics turned on, just briefly. That was the audio from the Florida court. Still nothing is, the camera hasn't moved. So just giving you a heads
Good
up.
afternoon, ladies and gentlemen. You're being called here today to preside over a case that involves what the state would qualify as unlawful bus conduct. In the state's opening, it indicated that on June 10th of 2024, Mr. Little was riding the bus. He was availing himself of the right to use public transportation. There was communication between the bus driver and Mr. Little on 2 occasions. In the first occasion, Mr. Little was interrupted with his ride to his destination when the bus driver at the downtown station asked him whether or not the box on the back of the bike that he had secured in the bike rack in the front of the bus was a battery or not. Mr. Little answered that question. The bus driver, Mr. Little, actually had to remove his earphones from his personal listening device.
We're pausing right here. We've got some action in court, and I'm going to bring you to it. Just one second. We've no audio yet. Let's see. Let's jump over to. Let's go. Hang on. That was still me. We need the other one. Let's go to 2 here. There we go. Still no audio. The judge is on the bench. I haven't seen any indication as to what we're called back for right now. Told you we would interrupt the gripping bus trial to bring us here. Let's see. Box 2 is going to be 2. Timer's still going right now. The judge has returned. We don't know anything other than that. I'm looking. I don't see anything yet. Jury question. Jury question. So no verdict, just a jury question. This could be quite insightful. Get to sort of peek into the minds of the jurors to see what they're hung up on or what they would like to do. It might be, what do we do if we can't agree? Might be hung. Juror question. It was his dad, wasn't it? I mean, the pew-pew. It was his dad. Can you just nod or blink twice if I'm right? I think that's what they're going to say. All right, let's let everyone come in and get seated. The judge has said that if it's a simple question, he'll write the answer on the question form and return it via the bailiff. If it's something a little more complicated, he'll bring the jury back out into the courtroom and address them in person. If they do pull them out of the deliberation room, I'll stop the timer, but presumably deliberation is continuing right now.
With Ms. Thornhill and Mr. Hendry, Mr. Levine is here for the state. The jury has a request. It's been reduced to writing. It's dated 2/4/25. It reads, Judge Abdoni, we are requesting court transcript from Susan Detman's neighbors, Sally Bell and Nancy Jones. Sincerely, Juror 1980896. Mr. Levine?
I'm amenable to any request, Your Honor.
Ms. Thornhill?
Well, Judge, we're not real time, and I don't believe that a transcript is available for that, but I could be wrong.
Well, I don't think we provide transcripts because it's required to be done in open court. All I can do is permit a readback or a playback, but I don't think there's a recording. So, is that correct, Madam Court Reporter? No playback? All right. So,
There is a recording, but it's not an official
bar
recording.
has recommended certain instructions in this instance. First, the standard instruction directs or suggests they be told that transcripts are not available, but that they may have testimony read back to them. And then I can combine that with the instruction that talks about how long it's going to take the court reporter to prepare it for readback, and then tell them to discuss their request further. And if they're not able to resolve their question about the requested testimony by relying on their collective memory, they should write down as specific as a description as possible of the part of the witness's testimony they want to hear. So I can do that, or I can say no. Just flat out no. So, Mr. Levine?
I'm fine with either one, Your Honor.
Judge, if I could have a moment to
All right.
discuss.
This is big. Like we talked about, that important part in the jury instructions, if the jury determines that kidnapping occurred. The instructions, the way I
say
heard it,
no, because there's obviously something they cannot collectively remember, but
Judge,
you have the look of, you want me to say no on your face.
I do. I should not play poker with you.
No. Well, I should not play poker with anyone because I'm not very good at it.
I hear that because I also am bad at that. At any rate, at this point, I think because it's such a general request, if you tell them that transcripts are not available and leave it at that, and then if they come back on their own with a more specific request, maybe we can entertain the idea of
they won't.
asking them if they, letting them know it would take a while to have a readback done, and if they can narrow down their request further, that would be helpful. So basically, baby steps. Start with no transcripts are available. Please rely on your collective memories.
I don't like that. I don't like
Please
that.
read their question one more time.
We are requesting, I think that says court, we are requesting court transcript from Susan Detman's neighbors, Sally Bell and Nancy Jones.
Your Honor, I'm fine with the court doing whatever he feels appropriate under the circumstances.
Why is he just surrendering and waving a white flag? I would say,
Is there some prejudice to taking two baby steps first
Yes.
and saying transcripts are not available? A readback may be possible, but we will need you to be more specific
I like that.
regarding your request or the portions.
How about 2.5 baby steps then? If you're not willing to tell them just no transcripts are available, please rely on your collective memories. Then add the step of a readback may be possible if you can narrow your request further. Just so that they don't come back and say we want all the testimony of both witnesses read, because that I think is a problem, because then we could get into having a readback of every witness's testimony.
I'm okay with this. I just don't want to tell them
All right,
there's
so let me
no.
cobble something together out of these various instructions.
I don't want to tell them there's no readback available, because then they won't ask for more. They won't limit. They won't self-limit and say, well, what about if we
How
ask for
long?
less?
Well,
30 minutes.
okay. Whether they, no matter what they want?
They were short, right?
Yes, they were
They
fairly
weren't
short.
the longest witnesses in the world, but they also weren't the shortest.
It is. I would say you're right, cat lady, ballerina. This is bad for Collin. The neighbor witnesses had no dog in the fight. They were independent of each other and observed the same thing, and both of them viewed this altercation. Their attention was drawn to the fight outside the house, the verbal altercation, the hair pulling. This is the kidnapping charge. This is where the kidnapping charge comes from. And if the jury finds that it was kidnapping, you can't. Then that is the instigating factor of this that has to overweigh everything else. Then, even if he says it was self-defense inside, you can't claim self-defense if you started it. And so if they come in and say yes, it was kidnapping based on the testimony of these two ladies outside, and one of them said, she went inside. One of them said that she was pulled inside, I think, if I remember correctly.
Judge, as I'm saying it out loud and as I'm writing it down, I'm thinking, though, if we ask them to narrow their request, then that might risk the possibility of highlighting a certain piece of testimony over any other piece of testimony. So I go back to my original request of just saying that no transcripts are available.
Mr. Levine?
Yeah, they
We're
don't.
going to say that there are no transcripts available. I think it should be included, but a readback may be possible.
Yeah, I agree.
Any response?
I'm thinking, it's like I said, it obviously would be helpful to know if there's a particular area that they are asking for a readback on. But then, like I said, that could highlight one portion of one witness's testimony, and they may miss some other part of their testimony if we just have a partial readback. But on the other hand, they're asking for both witnesses' transcripts of all their testimony. That tells me they're sort of fishing for something, which I don't think is appropriate for a readback.
So I'm not sure which.
So at this point, I think I'd rather you just say there are no transcripts available and leave the ball in their court as far as what they want to do beyond that. Usually in this circuit, the judges err on the side of not over-explaining, not over-offering. So
Don't play that
might be
card.
The best way to approach it.
I disagree with.
All right,
The
well,
jury is going to feel like their hand was slapped on this question.
the instruction
That's not
suggests
available.
that I can be somewhat generous in my response, but ask them to be as specific as they can. So I intend to advise them transcripts are not available, to discuss their request. If they can't resolve it with their collective memory, then they may request to have testimony read back to them, and that if they decide to make such a request, it should be as specific as possible.
That's acceptable to the state, Your Honor.
And over your objection,
Yes.
that's how they will be instructed. So let me just finish.
That's a good
Here.
call by the judge. I'm surprised that the prosecutor just waved the white flag and left it up to the judge to salvage that. This is a key moment. The jury deliberated, and the answers they get, the information they're told in response to questions.
All right, so my
Why don't you just sit there
intention
and
is
say
to
whatever?
advise the members of the jury you have asked that transcripts of testimony be provided for you. Transcripts are not available. However, a readback of testimony may be granted at the court's discretion. I now direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you may request to have testimony read back to you. If you decide to make such a request, it should be as specific as possible.
Good call, Judge.
All right.
The attorneys and the
We're ready.
judge, they know there's a transcript. They know readbacks exist. It's possible that the jury has no clue whatsoever. I'm gonna stop the timer just briefly because the jury is going to be brought in to hear that straight from the judge's mouth. So they're not going to be deliberating during that time. So we'll stop it at, boom, right there. Why would you leave it? The prosecutor, I realize, is on his own. He's a one-man show, and he's done an amazing job prosecuting this case, questioning every witness, cross-examining every defense witness, the few there were. But now is not the time to wave the white flag and just say whatever defense wants goes. Because it's almost like you're lying to the jury. There are no transcripts available. There aren't, but the transcript is the finished product after the readback has been certified. To say, oh, we don't do that, it would indicate that there's no record. You're just supposed to rely on your memory, and the jury would never come back and say, well, is there some other way we can hear it? They would be like, well, that was our shot. I guess who's got the best notes? What did you scribble down? Dr. Bullbutter, member for 15 months. Thank you. It's my birthday. I just stopped by to give RA and chat the best. Dr. Bullbutter, happy birthday. Happy birthday. I hope you have the best of birthdays. Did we sing to you already? No? Happy birthday, Dr. Bullbutter. There you go. Let's see. Not fair to the defense. The entire testimony of each witness should be read and not one comment or part out of context. Well, I think the limiting the area they want to question about is appropriate, because it would be the court reporter reading back the entire testimony in a flat voice, just verbatim off the page, no pauses. You lose all the inflection, you lose the body language, you lose a lot of the meaning. It's just the words are all that we have. And the reading, condensing somebody's testimony to that flat readback, I think also is, not right with the whole thing. Let's see. I'm so shocked the prosecutor was willing to let that go. I know. Forward me.
Members of the jury, you have asked that transcripts of certain testimony be provided for you. Transcripts are not available. However, a readback of testimony may be granted in the court's discretion. I'm going to instruct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you may request to have testimony read back to you. Again, that would be granted in my discretion, if at all. Now, if you decide to make such a request, it should be as specific as possible. You may now continue with your deliberations.
All rise, please.
The judge changed it one more time to make it, I think, a little more amicable to the defense, to show that this should not be something the jury relies upon, as a crutch throughout their deliberation, but they are in fact supposed to decide this based on how the evidence they heard.
I will also tell you, I don't know who told Mr. Hertel, but the jury verbally told him they want to end at 4:30 today. I did not ask him to have them put that in writing because they might change their mind. They know to tell him they want to go home for the evening, so I just left it at that. Any objection to that, Mr. Levine?
No, Your Honor.
No, sir.
All right.
So option 3.
Don't go far.
Yeah.
Tuesday night verdict is off the table if the jury wants to go home at 4:30. That gives them an hour and 10 minutes to complete their, either to ask their other question and get some readback done, or to complete their deliberations and return with a verdict. So we're looking more at a hump day verdict at best, or later. Phil, TYO Toys, nameplate fonts don't match. You're absolutely correct. That's bugged me the whole time, but now that you've mentioned it, it will bug me more. All right. We will stay here. We will return to here when the jury comes back. If they return with a more specific request for a readback, we'll be back with that. We'll listen in. I'm going to start the timer again on the deliberation. Just 1 second. There we go. And we're going to jump back to court where, up in Thurston, Washington, some of the most intriguing, captivating legal arguments known to public transit are being made. And so we're gonna jump back up there. Oh, let me do it this way. It's gonna go to 3. Oh, no. I'm gonna be 1. It's gonna be 3 for source. Box source 2 is 3. There we go. Okay, we're returning with Mrs. Rowe as she's questioning. She's actually giving her opening statement, which was deferred. So the prosecution has rested, and she's now continuing her opening statement about this bus behavior, which was so shady.
In order for the bus driver to hear the bus driver actually ask him a second time, was the box on his bike a battery? He answered that question, and it seemed to set the bus driver off. The bus driver immediately tells him, look, I'm just asking you a question, and if you don't like what I'm asking you, you can get off my bus. Mr. Little chose to exercise self-constraint and not reply to the bus driver's initial threat. The bus ride went on. Later in the bus ride, the bus came to a stop and 3 passengers got off the bus. The first 2 passengers got off the bus successfully, but the 3rd passenger was caught in the doors closing as she was getting off the bus. Right after, as she was getting off the bus and landing onto the curb, Mr. Little called to the bus driver saying, you just shut the lady's arm in the door. The bus driver's immediate response was to turn around and yell back at Mr. Little, she didn't say anything about it, so why are you? She said it a second time. If she didn't say anything about it, then why are you complaining? You just need to get off my bus. After this second order to get off the bus, Mr. Little responded by informing the bus driver that she was not allowed to order him off the bus without a valid reason. He then asked the bus driver to please call for a supervisor because he informed her without a supervisor, he was not going to leave the bus. Mr. Little was exercising his civil right to be free to utilize public transportation without being harassed unduly by a bus driver. The bus driver complied with Mr. Little's request and immediately called for a supervisor. The bus driver informed the supervisor that Mr. Little seemed pissed. And when she ordered him off the bus,
they said that word.
No, excuse me. The bus driver indicated on her call that Mr. Little seemed pissed. And he was yelling something about violating his civil rights. She never indicated that Mr. Little was being aggressive. She never complained that Mr. Little was being harassive. But she did have the wherewithal to at least notify dispatch that Mr. Little had just exercised and his civil right to continue on to use public transportation. A supervisor was called The supervisor arrived, and the bus driver explained her side of the story. What she indicated was that she asked Mr. Little about the battery, and his response seemed a little snippy, and that he had alerted her to the fact that she had closed someone's arm in the door as they were getting off the bus.
She seems like she's
Then
testifying
Mr. Rose,
here.
the supervisor, got onto the bus and began to conversate with Mr. Little.
Oh, conversating.
He asked Mr. Little what happened, and Mr. Little began to explain to him what had occurred. Mr. Little was offended. Mr. Little was distraught by the supervisor's definition of distraught. He was anxious, he was angry, and he was clearly invoking his right not to be removed from a bus for no reason. He did not commit any unlawful conduct. We heard from the state's witness itself.
Objection, argumentative.
Excuse me, I'm going to withdraw that.
Oops.
What we have today is a situation where Mr. Little was unlawfully removed
Objection,
from the
argumentative.
bus. He had engaged in no prohibited
Judge
conduct.
doesn't even respond to these.
There was no lawful reason to have him removed from the bus.
Objection, argumentative.
Okay, I'm going to sustain the objection. There's an opening statement. The argument comes later.
And unfortunately for Mr. Little, he was arrested on this day. The court has read the applicable statute that the jury must follow. And that statute first requires transit authority to ask Mr. Little to cease
Your Honor, objection in argumentative.
I'm going to sustain the objection. I'm going to remind the jury, the lawyer's remarks and statements aren't evidence or the law. The law is going to be contained in my instructions at the conclusion of the case. The evidence is you're going to hear from witnesses. And with that, Ms. Rowe, you have an additional 2 minutes of your time.
You're going to hear testimony
She's got a time limit now.
from Mr. Little.
The judge is wizened up.
And you're actually in the unique position to be able to view the transit recording of the entire bus ride. I am sure that once the court lays out the law that you have to follow in making your decision, and once you view the incident in real time on the video, that you will find Mr. Little not guilty of engaging in any unlawful bus conduct. Thank you.
They're going to watch an hour of live
Members,
stream
thank you,
bus
Ms. Rowe.
transit.
Members of the jury, we're now up against the noon hour, so we're going to take our lunch break. And we'll be back in session. If you could be back in the jury room by 1:25, we'll start with the defense case at 1:30. The instruction I gave at the beginning yesterday afternoon remains in place. Don't talk about this case. You can eat lunch together. Sometimes people bring lunch. Sometimes people go to lunch. You can eat lunch together. That's totally fine. But don't talk about what you've heard thus far. That would be deliberating, and it's not the time to deliberate. So it's
over just like that. So they killed the live stream. All right. So we have to take a lunch now. We have to take a lunch. We're forced to. We're in verdict watch on one channel with the court out of Florida, and the lunch break has arrived for our Thurston County Court. So on one hand we have an issue of transcript. On the other hand, we have an issue of transit. Ne'er the twain shall meet on different sides of the country here, but we're here for all of it today. The jury in Florida has told the judge or the bailiff, and not in writing, but just verbally, that they want to be done at 4:30. It would indicate that they probably are not all on the same page right now, or that some people on the jury, at least one, is not ready to make a decision, that they're not unanimous. They're probably, as most juries do, they probably just did a little straw poll, like, hey, where's everybody at? But that's just my gut feel. I'm not sure. But transcript versus transit. We're here for both of them. It's been a fun day. Sorry, my son was bringing me home. Did the bus driver testify? No. The only witness the state brought was the supervisor. So the defense is going to admit, I don't know how they're going to do this. How are they going to admit that evidence? It has not been admitted yet. How are they going to play, unless it's by stipulation, the bus cam live stream? 2 camera angles. One angle will show the lady who's getting an arm caught in the door, who apparently didn't complain, so why should you? This is going to be interesting.
Call from.
Hey, this is Scott. Who's on the phone? Hello? Hello? You've called the burner phone. You're live on the air. Sorry. I tried. All right. I've seen this horror movie. It doesn't end well. They want to beat traffic. Yeah, I would say that at least out of Florida, we don't expect a verdict tonight. We've got less than an hour for the jury to deliberate. Assuming they go back and say, we'll just use our notes, that's good enough instead of a readback. That's the best case scenario as far as time goes, because that won't bring them back into the courtroom and back out, which could easily eat up 15 minutes of time. They've only got an hour left to deliberate before the jury wants to go home. Apparently, the dinners they offer are not good up there in Washington, in Florida. Let's see. Can we have bus chase music while we watch the whole hour of bus footage? Yes, it would be a bit repetitive, but it would be this music the whole time. People getting on and off the bus pulling up to a stop, shaking the umbrella, closing it, putting the bike on the rack, climbing in, paying their fare. We could do that. Or just play our Suno playlist and let us stay here. I could do that. Not everyone's a fan of all the songs. I try not to make the channel entirely about music, but I do like music. I think that helps us reset and focus mentally. Have you seen Lori Vallow's latest filing? I haven't read the details, but I hear she's mad at Court TV. They were the reason why we got thrown out of, or at least one cameraman was the reason that we got thrown out of Lori Vallow's trial up in Idaho, because they zoomed in too close. So I haven't read the details. I've just heard the highlights. Dinners in Florida prepared by Sarah Boone. But no music's allowed on the bus. No music on the bus. You're right. There is audio on the bus. I'm hoping we get to hear it. I mean, if we have to sit here through an hour of bus video, I'd like to be able to hear what's happening.
Call from
Michael Victor.
Mr. Michael Victor, this is RA. How are you doing?
Mr. Recovery.
Yes.
Thank you for calling me. I have a couple questions for you.
Uh-huh.
Isn't it true you were watching my trial?
I hope so. Your accent's gotten a lot better since we watched.
Thank you. I was representing Natalie Corcoran. Maybe you know her.
Ah, yes. Are you not anymore? You're not going to do the appeal?
I don't think. Let me ask you a question. Isn't it true, Mr. Recovery,
Yes or no?
you make videos of yourself and put them on the internet for people to enjoy? Isn't that true?
I would say guilty as charged there, Mr. Victor.
Say yes, yes, or true.
Yes, true.
Isn't it true people pay you for these videos of yourself you put on the internet?
That I'd say not directly.
Isn't it true? Yes or no? Answer the question. Judge, tell him to answer the question.
I would say yes. Yes, they do.
Isn't it true you have been offered travel credits in the past?
I have.
Isn't it true? Yes or no?
Yeah, yes, I have.
How much taxes have you paid on such travel credits in the past?
I've paid exactly as much taxes as I have made use of travel credits. So dollar for dollar, 100%.
That's what I thought. Thank you. I got to go. I have a scam call.
Okay.
Bye-bye.
Bye. I don't know who that was. I have no idea. That was not Mr. Victor. I'm going with Uncivil Law or Greeners, Adam. I don't know who that was. Mathis? No, it wasn't Mathis. I can tell you it was not an international number. Mathis calls from international numbers. It was count on count. I don't know who put who up to that. I didn't recognize the voice. I have no idea. That's funny. All right. Let's see. We have a lunch break because we have to. Here's what I'll do. I can tell you what. Let's play a little bit of music. We're already on our second stream. I don't want to stop and start and have a third stream because portals don't work very well. So if you'll give me a couple minutes to step away, we will play a little bit of music, maybe from Suno. Let's see. We can start with our Battery Blues, which were the bus song. For those that missed this earlier, we did compose a little song that really summarizes the case out of Thurston County, Washington, and really sort of wraps it all up in one little musical ditty. I don't think you can say ditty anymore, can you? You can't. Anyway, we're going to listen to that one, and maybe we'll mix and match. How do I do that? Can it just shuffle around? Okay. Quick break for me. You guys get some music.
Mr. Little on the bus with a battery to spare. Bike parked in the aisle, though he didn't care. Lady driver asked him to kindly alight. Shook his head and said, not without a fight. Oh, Mr. Little, you're a stubborn kind of guy, holding to your battery, waving civil rights high. Bus is late, but you don't seem to mind, making a scene while time falls behind. Supervisor came with the frown on his face. Police called in to settle the case. Mr. Little stayed firm, wouldn't budge an inch. Everyone watched it unfold without a flinch. Oh, Mr. Little, you're a stubborn kind of guy, holding to your back. taking a scene while time falls behind. Falls behind.
Old man Joe just turned 74. Found a website, thought it was for more. Sharing stories about his younger days. Cooking breakfast in his own kind of ways. Signed up quick, put his pictures on. Fishing trips and mowing the lawn. Didn't know what it was all about. Just sharing life with no second doubts. Grandpa's OnlyFans, spreading love worldwide. Folks tuning in can't put their phones aside. He's gone viral, making money with grace, unaware he's in a different space. Neighbors whisper what they say ain't kind, but Joe keeps on, he don't seem to mind. He's buying tractors, fixing up his place with the earnings from his newfound fame. He reads their comments, laughs out loud. Grandpa Joe, you make us proud. Still oblivious to the site's true start, sharing his life straight from the heart. He brings his grandkids on for a morning chat, shows them how to fix an old straw hat. They think it's funny, but they don't tell. Just let Grandpa's stories ring like a bell.
All right, there we go. Got a little Grandpa's OnlyFans in there as well. All right, good. All right, two songs. That was a good break. We had both the Battery Blues and Grandpa's OnlyFans. So, all right, where we are right now in court, I can tell you we're at lunch break in Thurston County, Washington. Which is fine. The jury does, or the jury as well as all the participants in that court deserve to have a little break and eat as well. We are, if I can get to, let's see, box source 2 will be 2. There we go. In Florida, we are 3 hours and 52 minutes into deliberation, and we anticipate that this will not conclude today. Now, the jury could, of course, change their mind at any time, especially if they think, we all agree, let's just finish the paperwork and get it done. It could happen tonight, but it looks like that will be a slim chance, as they've said already, what time they want to go home today and then continue tomorrow. Does anyone know what Little's attorney's name is? Yes, her name is Gloria Rowe, R-O-W-E. And we've watched several trials with her up there in Thurston County, Washington. Did I miss the verdict? No, you missed a question, though. The jury asked a question, and they asked specifically if they could have a copy of the court transcript for two witnesses, the neighbors that lived across the street from Susan. These are the neighbors that heard an altercation when Kathy and Collin were there at the house, when Kathy showed up and witnessed the hair pulling and the yelling and everything that happened there. So they've asked for those two witnesses. I think that's a bad sign for the defense, because nothing good from Collin happened from those two witnesses. The only good we heard about that interaction came from the defense lawyer, as she sort of spun the story to say Collin actually placed his hand on his mom's back or shoulder or neck or ponytail to usher her inside. So it's like, hey, let's not air our dirty laundry out in front of the neighbors. That's not how the story was told by the two witnesses. So any recounting of those events that happens from those two witnesses will be very different from how the defense laid it out in their closing arguments. But let's see. Yeah, who was that called in? Who's going to own up to the call? I know Kurt. Kurt could do it. He can do some voices. He's really good with improv as well. Greeners and Adam, I would not put that past either one of them. How many jurors are going to run like Mr. Frog? No, I would say this. Thurston County, Washington has very few problems with jurors. Now, granted, most of the trials we see only have 6 per case, so there's less of a chance for them to go rogue, but very few problems with jurors. The one witness did call it the accident. Yeah, but she still recounted the altercation between the two. It was Josh? Josh, was that you? So it's not falsely documented that was not me. So it was not Josh on the phone. I don't know who did it. I mean, I could probably figure out, but that would ruin the fun. Because you didn't hide your number. I've got your caller ID. It was the same person who called before and didn't answer. I can tell you that much. I'm gonna look up the area code. Let's see if I can guess from there. Northern Virginia. I know Kurt has connections to Virginia. He's a licensed attorney there, but I thought he was in Texas.
Gotcha.
Here's another call. Ivan, my friend, how are you doing?
How's it going?
We're doing just fabulous. How about yourself?
Well, I just want the record clear, okay? I don't impersonate the victor. I am the victor. Okay, yeah. I don't impersonate other victors.
I would have recognized your number, Ivan.
Yeah, right. So let's just get that right out of the gate.
I think Amber put somebody up to it.
In any event, yeah. Well, I'm sure it was Amber. Sounds like something she'd do. In any event, I've been kind of castling with the verdict of this Mr. Collin, and I've seen some people say, insinuate that I'm not of the belief that just because it seems for sure that he's guilty of murder against his mother, that definitely means that the case with his father was fishy. There is this sort of phenomenon with when you get charged with crimes or you don't get charged with crimes, that you start to, if somebody gets away with something, right, they start to feel like they can get away with more, right? And so, but I don't necessarily believe that to be the case. I don't think it's just because he's guilty of killing his mother that negates that there was some kind of wrongdoing with his. I don't think that makes him on the hook for his father. I don't think that those are necessarily. I think those can be mutually exclusive events, if you get what I'm throwing.
Well, Oklahoma looked at the death of the father, and by not charging, there's an admission that we can't. There's not enough evidence for a conviction, right? That's why prosecutors don't charge. If there's not enough evidence, they can't secure a conviction. In that case, there was there was a assertion that it was in self-defense. And the prosecution might not have been able to prove otherwise. Now, if they have additional evidence, like if what the mom says exists, she said at 3:00 I'm going to release these videos, audio ring recordings of you confessing to the murder, saying you planned it and it was not self-defense. If they exist, open the case again.
I can also see a 16-year-old kid who obviously does not like his mother at all. You know, if they're going back and forth, I can see him, you know, as awful as it may seem, just throwing that out there, like, yeah, I really did kill Dad. You know, how do you feel about that? Like, suck on that. You know what I mean? Like, and so I don't know that necessarily makes that evidence. You know, I don't necessarily know that makes that, you know, worth reopening when, you know, I can see a contentious sort of relationship. I can see that happening. You know what I mean? Like, it doesn't seem like anything is off limits when it comes to those two back and forth. And so I don't necessarily believe, even if that does exist, I don't necessarily think that is grounds to open the case, just because, you know, a 16-year-old in the heat of the moment says something that he knows is going to get his mom cranked up.
Right.
You know, like, is that evidence? Like,
we didn't hear a lot of lying from him, because we didn't get a lot of statements from him, but we did hear that the mom was untruthful many times. That she would say she was doing something she hadn't. She didn't sell the car to CarMax. She hadn't canceled, you know, she hadn't done some of the things she said. She didn't send the recordings out like she said she would.
I don't know. I think he's guilty, and I think that there are a lot of kids like Collin whose family life just sucks, man. And unfortunately, when you have a lot of people who are parents that necessarily didn't get the grasp on their kid early that they should have, this can happen. And so that's why I always say, try to get the influence and respect of your kids as young as you can, because by the time they're Collin's age, it's way too late, as we can see. Yeah. So I don't think that a bad home life and a bad relationship with your folks gives you carte blanche to just do anything. But I just don't think that there is a good answer for this, other than he wanted to do this. He was, you know, and shame on all the people who just took his words as just, you know, as nothing. Like, he was spelling it out for everybody, but just because it's shame on them doesn't mean he has a pass either. Right. You know. But anyway, I'll get off the line here. But love you guys, and we'll talk soon.
Yeah, not a problem. Thank you, Ivan. Love you, man. We'll see you.
All right. Bye.
Bye. Ivan weighing in. Appreciate Ivan. Ivan and I are good friends, and I love getting his take on things. He's got a perspective that I don't have on a lot of things. We don't always agree, but appreciate him sharing. I do agree on this one, though, that I believe that Collin, to me, appears to be responsible enough that he could face consequences for bad decisions. So I think the only question, well, there are two questions now. Because of the kidnapping, there are two questions. The first question is, did Collin commit kidnapping when he grabbed his mom and pulled her by the hair and brought her into the house, or went to the house when they went in the house? Was that an act of kidnapping? If it was, you can't, even though, when he says self-defense, that means he did it. He was part of it, whether it was, you know, a mutual struggle or something. If it was kidnapping, then it's got to be guilty on either the first degree, second degree, or manslaughter. I don't see a way around that. I can't see positive guilty on kidnapping, but not guilty self-defense on the other. So that would be a miscarriage of justice based on the rules that the judge set out, or the law. If it was not kidnapping, then you can look at what happened inside and say, did the state prove beyond a reasonable doubt that this was not self-defense? And that is a higher burden. That's a harder thing to achieve, and I don't know how they're going to do that. But I think they can. I think the jury will probably settle with a lesser included on that one. So I think they're going to go guilty on kidnapping and lesser included on the other. Is anyone recommended a mental facility? No, he's been evaluated, and they say there's nothing wrong with him. Does not require treatment or medication. Let's see. If this was reversed and the parent did this to a 17-year-old, they would be guilty in 2 seconds. Why would we give a pass the other way? It's hard to imagine how these things would be reversed because there is parental custody issues. I mean, there's prior domestic assault charges and conviction. Yeah, it's hard to picture that the other way around. Didn't reach self-defense. Vix, I'm surprised that the defense left it the way they did, because the test. Well, let's think together. Let's rationally go over this. What evidence did the defense present that would indicate this was self-defense? There has to be some. You can't just say it was self-defense and not present any evidence. Sarah Boone tried that, and she had to get up and testify. What evidence did the defense present that this was self-defense? We did a bunch of polls, Tickle Pink. I can tell you that most of us thought it would be 2 to 5 hours on the deliberation, and we're already 4 hours. It looks like the jury's going to be going home before we hit that 5-hour mark. We've only got about half an hour left before the jury will be done for the day. They were trying to say the mother came after him first, therefore self-defense. How do you self-defense someone through the neck? That's a pretty specific game. It is, Allie, and the details of exactly how the crime occurred and the injury, those are difficult, but not impossible. They can be highly unlikely, but still possible. And I can't base my decision based on, well, there's no way she fell on a knife like that, okay? Because I've seen my kids do bottle flips. I've seen people do bottle flips where they land a bottle upside down on top of another bottle that's balancing somewhere. It's like, how in the world is that even possible? Odd things can happen. So I can't base my decision on the fact that, the knife was through her neck. That's as terrible as that is. It is possible. It is possible that a sharp knife like that one could go through the neck, and possibly. I mean, I don't know. The knife was 12 inches long. It could have, where her shoulder was. If she fell and landed on her shoulder, the distance the knife went through her neck could very well equal the handle size, that protruded out to where the floor would have been. There are things like that when I'm in my head, and as gross as that is, I'm like, I have to say that there's a possibility, although I can't envision it. In my head, I can't draw the scenario where she falls forward but lands sideways on the neck, with the knife exactly pointed at her neck with the blade up. That's a tough one. Emmy said it wasn't plausible. I agree. Not plausible. But just because a medical examiner hasn't seen it in their thousands of autopsies doesn't mean it couldn't happen. He put a knife on the couch. She tripped over his shoe, fell, and landed on the knife. It wouldn't have been on the couch. All the carnage was in the kitchen. But they could have been struggling. This is very likely that they could have been struggling in either situation. I think whether the mom had the knife or whether Collin had the knife, arguably I think Collin was probably the more likely person, because the knife would be used more logically to affect the outcome that Collin wanted than the outcome that mom was seeking in that moment. She wanted him to come with. It wasn't like or I'll kill you type thing. It was, come with me. Either way, I think there could have been a struggle. But the things that go really badly against Collin in this case are the fact that his mom is covered in bruises, and that pretty much she sustained all the injuries. I don't think they got any prints off the knife, did they? I don't think any of the knife was suitable for prints. And even if it was, I think the dispatcher had told them to clear the area, to get everything away, and he could have said, dispatch told me to lay her down on a flat surface and I moved the knife. That would have been really easy to account for, unless it was like a full grip, murderer grip print on the knife. Do you think not guilty? I think more than likely he did it. I'm fairly convinced that he did, especially when they say it was self-defense. It's almost a confession, saying, yes, I did it, but it was self-defense. And defense has presented that albeit without the confession part. So I think there's no question that he did it, and I just don't know if the state has done enough to prove that it was not self-defense. Why don't we have it? We just restarted the stream, Larly. Thank you, though. I appreciate you reminding people. No DNA on the knife. No DNA on the knife. They didn't do fingerprints that I heard either. I didn't hear any testimony of fingerprints. Did I miss that? The handle was covered in blood. We've shown you the knife, the image. I've got the actual image from the Sheriff Grady's. Let's see where it is. There we go. Here's the knife. That's the actual knife. So yes, I think they're. Well, there could be some prints on there. None jump out at me. They would sadly they'd be like blood prints. That knife is 12 inches long, by the way. As far as DNA goes, they shared a house. They lived with each other. Mom picked up after Collin. They ate together. I mean, the DNA in and of itself is not as helpful when there's a good expectation of under normal life conditions, DNA may be found there. So that's not as easy. Sheriff Grady is amazing. He gets his share of flack for what he does. Oh, Nikki, I didn't hear. Has the decision been made already? The ME did reverse the decision about Ellen's death. Well, that's another case that's. I tweeted out. I sent out a retweet. I think it was Brian Enton who said something on Twitter yesterday. I retweeted about that because that is huge. That is massive. We'll have to dig into that another time. That's a whole other story. They did test for fingerprints. Testimony was on one of the first days, but they didn't find anything, nothing suitable on the knife, right? Next case is going to be a tough one. Next case is out of Tennessee and involves a child victim. They're in verdict or jury selection, right now. We're in verdict watch. They're in jury selection. I don't know how long our break is. Do we have another hour? Let's see. Hey Siri, what time is it in Thurston County, Washington right now? Hey Siri, what time is it in Thurston County, Washington right now? Siri is not playing nicely. Siri's like, I'm listening.
Something went wrong.
Yeah, I can tell you what went wrong. You didn't tell me what time it was. It's 1:06. He said 1:15 is when they're coming back, right? So we just have a few minutes. Is it 1:15 at the return time for the court? Yeah. Megan Boswell, that's the case. It's tough. Wow. I don't know who sent me this. The video of a brawl, a breakout in a New Mexico courtroom. What in the world? Where in the world? Okay, we might look at this. bailiffs are tackling the defendant. Holy cow. I might need to show you this one. This is, I think we can do this. This is courtroom footage, so give me just 1 second. Let's see if we can come in on this channel. All right, just give me a second to bring it up full screen. I do not know the background on this. I don't know the history, so give me just 1 second. 3, rewind just a tiny bit. All we know is there's a brawl breakout in a New Mexico courtroom, and this is what it looks like. Posted just a few hours ago. Let me turn this off. Watch the defendant there. In custody, in cuffs. He's got ZZ Top as defense. Here comes somebody from the table. Whoa. The gallery is cheering people on and yelling. You've got a bailiff down there. We can see a bailiff trying to pull them apart. Punches being thrown. Flip-flops are left. I think those are the defendant's flip-flops. Hand to the face. Ooh, haymaker thrown. Somebody's got, oh, there's a half Nelson headlock. He gets out of it. The chair gets in there and is used against the defendant. She's using it like a spear. Mr. Nike just did it. Now has a bloody nose. Ooh, feet. Whoa! Taser, taser, taser. And here come the cavalry. Cavalry is like, sir, hands behind your back. Yeah, and you can expect to wear a nice shiny pair of bracelets as well. Everybody turn around. Defendant's like, look, this hearing's been rescheduled. All the other inmates who are watching there from the gallery are like, wow, we got dinner and a movie. This is crazy. Taser's still out. We need to get the scoop on this. Good grief. Good grief. This is courtroom gone wrong in so many ways. They need to clear the courtroom, get all the other defendants out of there. Everybody's getting locked up. Everyone's getting a nice shiny jumpsuit to wear. Guess what? You thought you had a hearing today. It's been postponed. It's been postponed. Back to the holding cell. But you've got a story to tell. It's like, but my arraignment. Yeah. New Mexico Department of Corrections. Wild, wild. We'll have to find out the detail. True Crime sent in a video from Mexico court to RA. Thank you very much. Who sent this? Yeah, it was True Crime. Thank you very much. That's crazy. Look above. Yeah, I missed it. I was busy watching the video. So while we're waiting, we have just a couple of minutes before we're going to be going back to court in Thurston County, Washington. Let me see if I can clear that one off. Let's see if they're back yet. They have not gone live yet. It's supposed to be about 2 more minutes, and then lunch will be over. We're still in verdict watch down in the Collin Griffith case as well. So lots happening all around. And we're watching no battery on the bus, says Sean. Yes. I tell you, you've got to take the good and the bad together. You can't skip it just because it's not as interesting. That was New Mexico. I'll do some research, see if we can find out what's happening down in New Mexico. It's a cheap, let me just say this. It's a cheap shot to go and attack somebody when they're wearing handcuffs, for anybody. And if you're a police officer and you do it, you should lose your job. But it's a cheap shot for anyone to attack somebody in handcuffs. They literally cannot defend themselves. All they can do is run. And even then, they're in flip-flops and can't do much else. Judge said 1:30. I think the jury's going to be back at 1:15 for a 1:30 start, so it could be a little later. Hey, is Mrs. R.A. here? I saw somebody say Mrs. R.A. I don't see her. Let's see. Honestly, the flip-flop part is the biggest indignity. What happened with the bus case? Did the guy testify? We are waiting for that. We've had the opening statement by Gloria Rowe, the public defender in Mr. Little's case. But we're now waiting to see if she brings the case in chief, which I think will mostly be video. But who's she going to call to testify? Who's going to authenticate the video that she brings in? Shouldn't that have been presented already? Probably with the prior witness, because I don't remember the state doing it. It's not admitted into evidence yet, unless it's by stipulation. It was a murder trial. The then uncle of the girl killed, attacked the defendant. Oh, man. Wow. Do we get any Corey Richards news today? Laura, I heard, I have not followed it, but what I heard was that the judge ruled that the reporter did not need to turn over her confidential information, her notes. Is that correct? Because that would be a big win for the reporter, not necessarily for the defense. A small win for the defense, but a big win for the reporters. If that's what I heard. I haven't heard anything else other than that. I think there was a hearing today. That was the ruling. No note. Okay. All right. Still no live stream out of Thurston. That's Karen Reed. Amy, yes. That's Karen Reed. Was that what you asked? Oh, you said Corey Richards. Corey Richards has still been fighting to keep evidence out. I don't know. I think there was a hearing that's happened. Different KR case. I'm sorry. Kelly, the Boswell jury has been picked and sequestered. Another sequestered jury. Wow. Yeah, Corey Richards, that's the Walk the Dog Papers one. That's Utah, Park City. We've been there in that courtroom a couple times now for a couple hearings to bring you that. What is that case with sequestered? That's the one we're hopefully going to tomorrow with it's the Boswell trial out of Tennessee. 25 is going to be the year of making sequestering great again. Are we going to be working weekends again? No. I will agree to this. The Boswell case is a very heavy case because it's a child that was allegedly killed by its mom, her mom. It's terrible. It received tons of attention because of the Amber Alerts that the mom helped spread, I guess you can say. There was a long delay between the child last being seen and the family, finally calling the police saying something's wrong. And so it's a delayed Amber Alert. It took weeks, I think, to find. I don't remember if it was actually Amber Alert, if it was just a search. It took weeks to find her, and eventually found the child's body discarded in a trash can on a family member's property. But we're gonna be going there. Boswell is doing court on Saturdays. Oh, should have told me that before I chose it. It goes to stand because they've got a sequestered jury. Of course they are. She was missing 2 months-ish before she was reported missing. Yeah. Did the verdict come in? Not yet. We are still sitting right here, 4 hours and 24 minutes. The jury has 10 and a half minutes before they say they want to go home for the night in the Florida case. I don't think we're getting a verdict in that time. Oh, when the two KRs overlap, it's going to be brutal. Yeah, someone else can take those notes. Happy about Saturday court. Saturday court is fun. I like to be here on Saturdays. Casey Anthony 2.0. Yeah. Notice how the jury did not come back with a follow-up question. ASAP Rocky has the draw to that one is the big names. You know, Brianna in court. Okay. Krista, thank you for the news article out of New Mexico. This is from KOAT Action News 7 in Albuquerque, New Mexico, under the article written by Corey Howard. Says that Friday morning, this last Friday morning at 9:30 a.m. in courtroom 420. I know a lot of people like that number, so I thought I'd share that with you. They had a brawl. Alexander Ortiz was charged of murdering Eliana Farfan. Farfan's uncle leaps the gate, punches Ortiz. Ortiz and the officer by him fall to the ground. Then police, second guy says Pete Gisazi joined the brawl. Joe Ray Ortiz's father, joined the scrum to defend his son. Joe Ray began punching Lucero and Gisazi. Melee goes on for about a minute with more people rushing in. Eventually, deputies restore order by handcuffing Lucero, Gisazi, and Joe Ray. At the same time, Ortiz is taken out of the courtroom. The attackers were both charged with felonies, which include battery upon a police officer and assault on a jail. Assault on a jail. Inmate, maybe. The defendant, Lucero, explained why he did it, saying, "He killed my niece like a coward. It was worth every moment." So I'm guessing a guilty plea on that one. Meanwhile, Joe Ray told officers he was trying to break up the fight. Wow. That's wild. All right, Thurston County, still waiting for the return. I wonder just how much witnesses we're going to have in this bus case. If it's just going to be video or what? Nicola, thank you very much. I understand. I'm afraid to leave because we'll get a verdict. This is true. This is how it works. We're now 7 minutes away from the jury going home in Florida, and I don't think it's going to happen. What are we waiting on? A question? No, the jury's deliberating. They asked an initial question asking if they could get readback, or they could watch the testimony again, and the answer was no. They wanted transcripts. The answer was no. They can get a readback if they give a very specific request, like we want this answer, or when she was talking about XYZ topic. But they have not come back with that clarification. That instead, all we know is that the jury wants to go home at 4:30, which is in 6 minutes. Voted 2 to 5 hours. However, that was before I knew that was mostly women. LAW, I don't know what the jury makeup is. If you've seen that, do share that with us. We know that there were 3 women who were excused as alternates, but I don't know the jury makeup. And I don't know how that would change things. I know for me, I can only think of one thing at a time, but women are very good at thinking of multiple things at the same time. Bev cut it off short today. Yogi, I'm sure this has been answered, but why can't they see the transcript? The official transcript is takes months, sometimes 6 months after a court case to actually be certified and filed. It has to be reviewed by the court recorder, who goes over it over and over and makes sure everything is absolutely correct, and then it's certified. So that's the transcript. There is not a transcript until that happens. The court does not rely on media coverage, video, for some reason. I don't know why, but they don't rely on those happenings. They only rely on their own recorder. So you can have the court recorder who's typed it up in sort of like a shorthand typing, whatever the stenograph, whatever thing is, stenographer. She can read back what is in her notes using that special little language code she types in. But there's not an actual copy that anyone else could read unless they knew how to read that type of shorthand. They're using court TV footage to impeach the witness in ASAP Rocky. I saw that somebody tweeted something, and that was brought in. It's a pretty interesting Twitter handle as well. Yeah, the actual language the court reporter uses is more like all the sounds that are made in the English language can be broken down into a list of, sh is one sound, and sh is another sound, and all the sounds that make up letters and words and sentences are broken apart that way, and the recorder records the sounds. So you're reading back the sounds that you heard to make the words. It is a shorthand. It uses a lot less keystrokes to capture that. But Mom interrupted. Welcome. Looks like you clicked the subscribe button. Welcome to the group. You can never leave now. Lots of times court reporters hire typists to do the transcript. ASAP Rocky, it just looks like ASAP. Is he like a musician or something? I don't know if he is. Melanie Little's covering one in MA that is crazy. Can't believe the woman got charged. Is that the one with Bev? Judge Beverly? That's in PA, isn't it? He's a rapper. Okay, that's why I probably haven't heard it. ASAP is married to Rihanna. Rihanna was in the courtroom. Still deliberating, yes. Let's see if the Thurstons come back here. Still nothing in Thurston. How many voted the verdict beyond 5 hours? I think about 55% of us said the 2 to 5 hour range, which technically takes us into tomorrow because we're only at 4.5 hours of deliberation in See, a minute and a half, they'll be done. Okay, so yeah, it is an MA, not PA. She got charged with manslaughter after her husband had a heart attack when they were having an argument. She caused the heart attack? That might be a little much. Laurie, courts are very behind when it comes to technology, and you'll see it. I talk about it with Joshua on our interview we did yesterday with Courtroom Confidential. But courts are very slow to adopt new technology. Play the little song again. I've already played it twice today. Yeah, a lot of people don't have a lot of hope for Judge Beverly. I don't give her as much flack as other people do. Yeah, what's up? Hang on. Tomboys, welcome to the gallery. Thank you very much. When can we see that video? I forgot what I was saying because my kids distracted me. Which video? We're going to be back up in Thurston, Washington here momentarily. But they say they're live. Yep. Now it's live. Here we go. Here we go. Took a minute to kick in.
Little is electing not to testify. And so I wanted to make sure we address this.
Let me back that up.
As a result of this breakdown in communication, Mr. Little is electing not to testify.
The interview is going to be in a week or two.
So I wanted to make sure we address this outside of the jury.
Okay.
It's my opinion that our communication broke down when it comes to the questions that Mr. Little may or may not have wanted me to ask.
Yeah.
So Mr. Little is indicating that he is not electing to testify.
Okay.
Well, I'm going to need to adjust. I'd like to address the court, Your Honor.
What's that?
I would like to address the court
In
response.
You can't. You've got a lawyer. You'll have to fire her first.
What do you wish to say?
Mr. Rowe just handed me this note as I walked back in after the break. It says, I will be notifying the court that you will.
Okay, you need to slow down, okay? And so I don't understand you, frankly, when you speak that fast.
Because I don't have my teeth in and they cause me pain. And I rarely ever wear them. I had to take them out at the break. The note says, I will be notifying the court that you will not be testifying and we will let the video speak for itself. I do not disagree that we've broken down communication, but during previous hearings, I made it clear to the court that my own lawyer and defense, Lord, Your Honor, in open court, that my stipulation with the continuance was simply because I expected the testimony I expected to impeach the testimony of the driver and use the video as prima facie evidence to essentially refute the prosecution entirely. And unfortunately, right now, most of the evidence is left on the table. And I've asked most of my previous attorney, who is a public defender, this, as you know, is a court-appointed panel attorney, and my previous complaint was that I did not get any communication that I expected an affirmative defense. But this is retaliation for complaints. And no one is willing to put forth the effort to make that case. I mean, I understand but the point is, my Freedom of Information request predate this incident by months, almost a year. Same issues that we're addressing here about sleeping on the bus, all those things I raised with them. And there's a mountain of evidence that is not going to be tolerated in a limited court of limited jurisdiction for a misdemeanor at this level. And that's why communication is broken down, Your Honor. This is, as I mentioned, and you'll see in the record, as I made the case to the previous attorney, the previous judge during the previous hearing, that I briefly lost my train of thought.
I tell you, don't sleep on these bus trials.
Essentially,
they're spicy.
I might be able to clarify a couple of things, but
before we do that,
are you firing your attorney?
So, Mr. Little, here's where you're at. We're halfway through a trial. The state has rested. It's your time to either testify or present evidence or not. You don't have to. It's not uncommon for folks to not present evidence following the state's case and argue that the state hasn't proven it beyond a reasonable doubt in various elements here and there. And my understanding, I'm learning about this case is I don't know as much about it as anyone else here, but I learned about this just over the course of the testimony here today. And I'll be frank with you, in that my sense is that a lot of things that you think might be relevant and important to this case and admissible and the jury should hear are not. They're just not. And, and Ms. Rowe is bound by rules. She can't knowingly, intentionally violate the rules, ask you questions that she knows that would sustain an objection. And
Your Honor, we've had no
things of that sort. So hang on, I'm not quite done yet. You don't. Please don't interrupt me. I promise not to interrupt you.
I'm not a bus driver.
And so that's where we're at. And so we're going to finish the trial. And if you. And again, I think that you need to work with your attorney to see what you want to do here. If you want to testify, you can testify. If you want to not testify, then you don't have to. And there'll be an instruction that says the fact that you didn't testify won't be held against you in front of the jury. I'm going to hear from the state. Ms. Rose said that, well, we're going to let the audio, the video speak for itself.
How?
I'm not sure that's going to happen, because in order to get something into evidence, or you usually, unless it's stipulated to, but that's usually in conjunction with testimony of some sort. If this has taken me by surprise, as I suspect it might be taking Mr. Thompson by surprise, so I haven't done any research in that regard, but that's where we're at here. And I've noticed throughout the course of this trial, because you're right in front of me, you've been fairly demonstrative about writing notes and handing them to Ms. Rowe and, making sure she does this and making sure she does that. But I'm going to assume too much. You're not an attorney?
Oh, Your Honor, but
okay. And so you're not trained in the rules of evidence, not trained in the rules of criminal procedure, and there.
Need to pause because we're going back to Florida for a second. Which is right here. We'll be right back to figure out what happens with with that case in Thurston County. Judge is back. Looks like the jury's being brought back in. We're just waiting. The bailiff is here. Looks like he did a close shave this morning. Looks great. Getting dizzy. We're trying to watch two courts at the same time. And we could keep it going while we're waiting if you want to. If you want to watch two at the same time. Here we go.
There are many attorneys who, frankly, not even sure I do, have a great handle on the rules of evidence. It's a complicated subject. And like I say, there are just a lot of things that you probably want that aren't admissible. But we're going to brainstorm how we're going to finish this trial here today. But we'll go from there. And so now you can speak if you wish to.
Your Honor.
I'll give you a chance too, Ms. Rowe. I saw your hand up behind it.
I understand rules of evidence. I understand how to look up rules. I've spent a lot of time in the Temple of Justice in the law library looking things up myself. I'm not an attorney. The point that I lost a second ago is that this case is ancillary to an action that I intend to bring under 18 U.S.C. 242 for violation of rights under code of law. Everybody knows this because I made it well known for a year at least. And my point is simply that I have no problem testifying. My point or my problem is with the amount of evidence that's being left under the table. That would support my case.
I'd like to respond.
Well, I will let you in a minute. First of all, there's nothing, regardless of what happens here, that's not going to stop that. There's nothing to stop you from bringing a suit. You're free to do that. That's not going to have any bearing on that at all.
Anybody you want to.
And I guess
I think the evidence should be introduced now rather than later. And if it doesn't get introduced now, it can't
what is this evidence?
I'm not an attorney.
What is the evidence that you wish to? I'm just mainly out of curiosity.
Mostly video and audio recordings that were turned over to me, and also policies, procedures, everything. When I say I have an amount of evidence, I'm guessing.
Okay, we're going to jump back to this court.
The jury informed the bailiff they want to recess for the evening.
Yep, they're going home.
I'm just going to give them some reminders.
So 4.5 hours of deliberation today, and they have not been able to reach a verdict. Collin saying this water's good, drinks it all. We're going to see if Mr. Little fires his attorney and proceeds on his own in just a moment. It's wild. Waiting for the jury right now. Convention prep. They have to finish by 5 p.m. That's funny. Corey, thank you very much. It is hard to predict juries. It's almost impossible. jury's coming in. We're going to hear the judge give them an admonishment and then send them home for the evening. They'll come back. They're not sequestered. They'll come back tomorrow morning and continue their deliberation.
Please be seated. All right, ladies and gentlemen, I've been advised that you wish to retire for the evening and come back tomorrow to continue deliberations. I'm going to grant that request. I've told you this part of the trial, the schedule is in your hands. Just those same reminders. Please don't talk to anyone about this case or let anyone say anything to you. The folks you are closest to may know that you're now deliberating, and they're going to be very tempted to ask you questions, although I am certain that you've informed them how important it is they not do that. But if they do, just tell them you're still under that strict order, and if you want to, you can talk to them as much as they want to talk to you about it when the trial is over. Please remember not to look anything up. Please remember to avoid those parts of the news that I've told you not to expose yourself to. And I hope that you have a restful evening. Please report back tomorrow morning at 8:30.
All rise, please.
8:30 is the start time tomorrow morning. The recorder in this courtroom is doing a verbal record. They use a Darth Vader mask that she speaks into. It's, as far as I know, it's just verbatim what she hears she says, which seems like it's not the smartest thing. It's a duplication of effort.
Judge, do you want us to be up here at 8:30, or is there no need for that?
Yes, I would like for you to be up here at 8:30.
Yes, sir.
All right. Because they'll be brought in.
Okay, that was what I did.
Just briefly, so. All right. I'll see everybody tomorrow morning at 8:30.
All right. With that, we are going to go to back up to Washington, where we continue
somewhere
with Mr. Little.
between 75 and 100 gigs worth of information that's been turned over to me by the inner city train. And it includes their training, their policies, their procedures, and also the video.
So, Ms. Rowe,
you've given me it's not continuous, Your Honor. They've let things out.
Okay.
There we go.
I think you overheard something like that.
Ms. Rowe, you wanted to say something?
Because it wasn't subpoenaed. It was simply what they turned over to me. And when I asked them, why is there pieces missing out of this video? They said, well, if you I have to show you the email that I got from them. If it's necessary, I can produce it for the court, and I'm happy to do that. But they said that the exculpatory video, where she said it wasn't relevant, which shows me on the way into town, not the incidents that happened on the way out. The driver accused me of being in the recording. The driver accused me of being out of control. That's not exactly what she said. I don't remember what she said verbatim. But when I requested the video of the inbound route, the information officer said, well, it was automatically deleted because it wasn't relevant.
So when you say inbound, is that on your way to the bus stop?
Yes, sir.
Before this
I got on
ever
Walmart,
happened?
and in the video, you will see the video that
we got a
I hope
Walmart.
you're still able to present.
Okay, but hang on, just so clear, the video before you had any interaction with this bus driver, you say that's the stuff that's missing?
There are several sections missing.
Okay, but is it before, this was stuff before you had any interaction with this bus driver? How many sections? Well, I've heard about you got into it with the bus driver over a battery in downtown, and then got off the bus, and then the bus took off and things accelerated. And then we heard about where it happened in Tumwater.
You got the sequence wrong. I got on at Walmart in Tumwater.
Right.
Rode downtown without incident, without any conversation.
Right.
In the video, you will see that I go to the locker, I retrieve my bike that's broken, and I put it on the bus, and I'm attempting to shuttle my bus back home, or my bike back home, because it's damaged. It's got a broken chain and a broken gear lever. Excuse me, a brake lever. So that was my whole point. All I did was go retrieve that bike from secure lockup
Right.
put it right back on the bus and go back to where I live in the bushes.
And yeah, and that's when that happened in Tumwater.
Yes, sir.
Okay. And then when you got your bike, that started the interaction with the driver about what's that? Is it a battery or not? Right. Okay. So whoever told you that the part of the bus ride going from Walmart to downtown was not relevant is 100% correct. It's not.
Your Honor.
And again, I'm just saying that wouldn't, even if you had that wouldn't be admissible. You can disagree. That's fine. I have people disagree. Okay. So
to the dispatcher says he was out of control on the way down.
Okay.
And she's using that as the basis.
But hang on just a second. But that didn't come into evidence. That's not part of this. What's happening is what happened after that. So that's not even an issue. It never came up. It's never, that's not relevant either. Whether you were out of control on the way down, that's not relevant at all.
But the supervisor said that that's the basis for why he showed up in the first place.
Okay.
Because I was out of control and harassing the driver.
Okay.
No.
Okay. So hang on just a second. So listen to me. That's not my recollection of the testimony. And we're not going to go much further into this other than we're going to figure out how we're going to finish this trial here today and then go from there. And if the Tumwater did any sort of, you're free to submit any sort of freedom of information requests, something may not be available, but the relevant evidence is what happened at the bus station over this battery, and then what happened when Mr. Rose showed up. And there's testimony on that. And your attorney cross-examined the one state witness on that. It's your turn to present a case, and so I guess I'm going to go back to Ms. Rowe wants to say something. So I'm going to hear from her as to what's going to happen here today. And then Mr. Thompson, I don't know if you want to say anything or not, but I'll get to you in a second. Ms. Rowe?
So I've got a few things to respond to. The first thing I want to respond to is when Mr. Little indicated initially, when he started speaking with you, that he believes that there are some retaliatory actions towards him from the state actors. That's what he was responding. That's what he was addressing, not retaliatory actions of me towards him. They were what he perceives as retaliatory actions of state actors towards him. And these are based on the civil issues that Mr. Little has been explained and over-explained to him are not relevant in this criminal trial. Second thing I'd like to address is he himself has just acknowledged that there was no communication between the bus driver and he before the video, before they arrived downtown. So although he would like to have shown that video and get things on the record in what seems to be in preparation for his civil case, I had to explain to him, as this court just corroborated, and that is that portion of the bus ride is irrelevant to this incident.
Okay. So, Mr. Thompson, do you have anything to add to this?
I'm not done yet.
Oh, I'm sorry. I thought you were.
I'm not. The third thing that I would like to address is the fact that yesterday, well, first of all, Mr. Little's, to cut a longer argument shorter,
I would appreciate
Mr.
that.
Yes, Thompson, please. Even this morning, has indicated that he has no problem stipulating to the video that shows only the 2 times of the incident that is being litigated today.
Okay.
So I would argue that because he's already stipulated to that, and because it has now been condensed into a much shorter form, that we should be able to play the video. It consists of 5 recordings that total 42 minutes and 69 seconds, some of which, when the jury gets it in front of it, it can forward through. Now, so I just wanted to let the court know that I did go through. I did delete everything that is not connected to this specific incident and does not show the only 2 times that the bus driver had any communication with Mr. Little. Those are on the video. And I noted that the state did not call its arresting officer. The last video shows contact with law enforcement with Mr. Little, and then it wanes on to actually show the arrest. So if the court, so in conclusion, the totality of the time would be 43 minutes. The reason why, and that is the reason why when Mr. Little read to you what I had written to him, and this is because he stopped speaking with me and would not answer any of my questions. This is when I said, I'll notify the court you won't be testifying. And I was telling him, if that happens and he doesn't testify, we will let the video speak for itself. It is my firm belief that once the court and the jury watches the video, it will see that Mr. Little did not
Okay, you don't need to tell me what I'm gonna, it's not important for me. I'm not the fact finder in this case.
Understood, Your Honor.
Okay, are you done now?
I am done now.
Mr. Thompson.
And Your Honor, it sounds like the defendant's not testifying, therefore the video won't be coming in as no foundation can be laid.
Oh, he plays hardball. No stipulation.
No.
I would like Mr. Little to be able to be given the opportunity to change his mind.
Let me think for a second, please.
I thought they were going to stipulate to it.
Mr. Little, you wanted to say something?
I beg your pardon. I didn't mean for this to be this long, but the reason why I insisted on showing the video, and my attorney has mentioned that she does not intend to ask me any questions, because the reason I requested, according to Mr. Rose's testimony, I'm the one who requested, as my attorney brought out. I'm the one who requested the supervisor come on site. And the reason is because I needed to report the driver using her cell phone multiple times while she's taking it out of her bag, while she's going down the road in operation of a motor vehicle, speeding in violation of a U.S. SPSCC driveway, the posted speed limit, and failing to stop. I mean, there's multiple traffic infractions that I was attempting to report to the supervisor, and he wasn't listening to any of it. All he wanted to do was get me on the bus away from the recording where I could be isolated. That's my testimony in court. Will be my testimony. I'm happy to testify.
Okay. So
I would appreciate it. Here the evidence, the relevant evidence, which is the fact that I'm trying to report a driver for gross misconduct, or at least serious misconduct, using a cell phone is a moving violation. Doing it 3 times on a single ride is a fireable offense.
Okay.
And that's why they're fighting so hard.
So here's where you're at. So I tend to agree with Mr. Thompson in that in order for you've said you have no problem testifying, but I'm not inclined just to play and I know what Mr. Thompson, what the stipulation was, but I'm pretty confident that stipulation came with the expectation that would be accompanied with testimony from Mr. Little. And so I tend to doubt there would have been that stipulation absent that understanding.
I disagree. And I believe that even if Mr. Little doesn't testify, the video shows the bus driver and Mr. Little.
It's an admissibility thing.
Is self-authenticating. The jury has had a whole day to see what Mr. Little looks like. Right. They will see Mr. Little's presence on the bus. They will get to view the entire portion of the video that deals with the issue litigated today. So I would argue that it is self-authenticating. And even if Mr. Little does not choose to testify, that it would be self-authenticating because you can see the ride itself and you can see the 2 parties that were involved on the video?
Mr. Thompson?
Your Honor, I don't believe it would be self-authenticating since we don't know when it was made. And that's a necessary element of authentication. It can't authenticate itself with a date and time.
So here are your choices, Mr. Little.
You take the stand.
Well, if you choose not to testify, then we're going to add the instruction, which I took out over the noon hour, but we can add that back in, that says the fact that you haven't testified can't be held against you, and we're going to proceed to argument. Or you can testify, and then the video will come in, and you can provide commentary on that if appropriate. I want to tell you one thing, though, and that is if you do testify, if there's an objection made, you need to stop. Do you understand that? Because I will tell you, just based on what you just said, some of the things, I'm not going to prejudge this, but some of the things may not be admissible and may not be relevant. You need to understand that. So you need to decide with your attorney right now what you wish to do.
My decision has never changed, but I'm willing to testify.
Okay.
All the
Then we'll bring the jury back in, and then we'll swear you in, and we'll go forward.
Your Honor, I believe that there are going to need to be some guidelines set forth now, because I believe the court will need to specifically let Mr. Little know.
Please stop. So I'm not going to be able to, I'm not going to tell him right now, yes, you can do this, or yes, you can't do that, because I don't know what he's going to say. What I've already said, I'll say it again. If there's an objection, you need to stop. You understand that? Or if you go beyond that and I find that it's inadmissible, I'm going to tell the jury, you're not there to disregard what you just said, because I'm striking that. So, and I know you disagree with it, and maybe you don't understand my rulings, but that's what we're going to do here today.
My attorney will tell you that I was more than willing to provide abundant discovery for the prosecution.
Well, and like I say,
because the evidence speaks for itself.
I'll end where I began, in that just a lot of it, I think there's a very good chance that it's just flat not admissible, even though you think it might be. But anyway, we're going to try as hard as we can to get this trial in here today, and then Ms. Rowe on this video. Do you know where like the stuff that you need to speed through, is that just random bus riding with nothing?
Yes.
Yeah, I don't want to show that to the jury.
Thank you.
And so I just want to,
random bus video.
Because if it's just peaceable bus riding, that's not helpful. We can even stipulate to that so they can know that.
Your Honor, let me break it down for you. The very first video that I'm seeking to introduce contains the first incident of contact between Mr. Little and the bus driver regarding the battery.
Okay.
The second video is the incident where 3 passengers were getting off the bus and the bus driver closed the third driver in the door.
Okay.
And immediately as that's happening,
you can't make
the minute she got out of the door, Mr. Little then communicated with the driver, you just closed the lady's arm in the door. So that's the second video. Third video is where Mr. Rose responds to the incident, him getting on the bus and having a conversation with Mr. Little. That's the third video. The fourth video is mostly just probably doesn't need to be shown. However, it does show that while
then don't show it.
The supervisor was waiting for law enforcement, Mr. Little got up and told the supervisor that if he could drive him to his location, he'd be willing to get off the bus. And the supervisor saying, I'm sorry, I can't fit your bike in my car, so I can't do that. And then the last video is law enforcement contacting Mr. Little on the bus because Mr. Little had refused to even leave his seat, having some communication with Mr. Little, and then arresting him.
So can you fast forward through various places to get to those points?
I most definitely can.
I would.
The state won't have an objection to that, Your Honor. The jury is going to get access to all the videos if they so choose to watch the bus ride. So
there can even be a stipulation. This was without incident and everything was fine. during that time period.
Mhm.
All right. So, Mr. Again, I'll just say it one more time there, Mr. Little. We're going to come in and I'm going to swear you in. And again, if there's an objection, you need to respect it and respond to it. So I'll tell you anything from a practical point of view, if you get into an argument and pushback and all that sort of stuff, it's probably not going to help you too much in front of the jury. And that's just, maybe I've said too much, but you might want to think about that too.
Those were very wise words, Your Honor.
So we can bring them back in.
And Your Honor, before they come in, can I elect to play the video first and then bring Mr.
Well, let me
Little up?
swear him in. You can find out, lay a little bit of foundation and who he is. And this is going to be a video of the situation. Do that first. I'll just start with the video.
Mm-hmm.
That's smart because he might change his mind after you play the video. So you guys, this is absolutely crazy. This is the fact that this prosecutor took this case file and said, yeah, this is one I'm going to pursue.
I'm just going to say, I'm going to hold you back there for just a moment. I promise you're close. And that is one thing I was planning on saying before I came down here is I would urge counsel to avoid repetition. This morning I noticed in the testimony, things were repeated several times, which wasn't necessarily necessary. And so just kind of be mindful of that so we can, I still have dreams of finishing this trial today. Go ahead, Ash.
It's a pipe dream at this point. Charged with unlawful transit conduct. He wouldn't get off the bus when asked to. This is Tumwater, city of Tumwater, Thurston County, Washington.
You can be seated in the courtroom. So, members of the jury, thank you for your patience. I know we're starting a little bit later than we had anticipated. It's all of my responsibility to run the court on time. So if you're looking for someone to blame, you can blame me. So I apologize for making you sit back there longer than necessary. And when we broke, the state had rested. Ms. Rowe gave her opening statement. And now, Ms. Rowe, you may call your first witness.
Thank you, Your Honor. Your Honor, if I could call Mr. Kenneth Little.
Mr. Little, you can come up here to the witness stand.
Get a rare view of Mr. Little. But you're going to hear him.
Raise your right hand. Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth? Yeah. You can be seated.
So help me God.
And Ms. Rowe, you may inquire.
He added that part.
Miss, I'll let you put your device on first.
I may be able to hear you. You're facing me.
You will be able, you can hear me?
Maybe.
I have a pretty loud voice too also. Mr. Little, if you could you state your name for the record?
Kenneth Little.
And Mr. Little, are you familiar with the incident that is being litigated today?
Yes, ma'am.
I'm assuming you're familiar with the incident because you were the person involved in the incident. You were one of the people.
The victim, yes, ma'am.
The victim. He testifies. I was the victim. Yes.
Can everyone hear? Okay. Okay. So, Mr. Little, I'll ask you to speak just a little bit louder for the jury there.
Thank you.
She take notes
and
every time she talks.
During the course of this case, were you able to receive video evidence of the incident as it occurred?
Yes, ma'am.
And was that video evidence provided to your counsel for viewing today?
Yes, ma'am.
Laying the foundation, trying to get the video in. I think Mr. Little is homeless because I think he said he was trying to bring his bike back to the bushes where he lives. It went quick, but I think I heard that.
Your Honor, I would like the opportunity to address the videos.
You may.
Mr. Rowe, may I retrieve my notes that I was taking?
Yes. Would it be this pile of things right here? Your Honor, Mr. Little is requesting his notes. Okay. So I'm going to hand those to you.
Turn them over to defense first.
You may.
The state has to help to play the video.
Defense exhibit number 2.
Whatever you do, don't push the. We can see part of it. We can see part of it. At least give us that. Don't push it off the screen. Don't touch it. Okay. Trying to figure out how they work the USB drive. Most courts would be able to plug in right into the Zoom as well, but not this one. There, now don't wiggle it, just like that. There we go. Flash drives in, recognized by the computer. The defense has the right to request to see the notes that you're using to refresh your recollection.
Screen, please.
We're going full screen. At the witness's request. Oh, we get to see the bus driver. Yes, this is good. Okay. Zoom, 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 zoom. Sorry, that was past my house, not on the bus. Turning to the right. Everyone lean in your seats as we turn. And it's going to straighten out here. Turn to the right again. Everyone lean. Corners. Now straighten back out again. I guess we do a lot of turning to the right because that's where the bus stops are. Oh, big corner to the right. Hard 90-degree turn to the right. Please shift camera. I can't make it any bigger than actual sizes, which is what it is. One attorney row is going to block what little view we have. She paused it. Nope. It's still going.
Yeah, I was just going to ask you to move a little bit so I could see, and you did. So thank you. Oh, you're good.
Judge wants to see too.
I'll move this way.
Oh yeah. Oh, careful. That's.
Is that better?
That's perfect.
Okay.
Now we can't see Mr. Thompson, but that's all right. Mr. Thompson doesn't even want to watch the video. He's seen it before.
So, Mr. Little, do you recognize where this bus is stopped?
Yes, ma'am.
And where is that?
That's at the number 12 stop at the end of the block.
Okay. Is this the stop downtown?
Yes, ma'am.
Okay.
The very edge of the screen, we see the bus driver's head. The camera is sort of like up above the bus driver's head looking down. So we see the bus driver's head, and we can see where she occasionally grabs the steering wheel and turns. And then the brighter part of the screen, which is just on the left side, is the window straight ahead, so we can see. That's it. But I'm not hearing any audio, even though there should be audio. I think she just skipped ahead, or she's trying to. Oh, somebody just appeared in front of the bus. There's Mr. Little adding his bike to the bike rack in front of the bus. He lifts it up, sets it down. We see that big box on the back. That's the ammo can. It looks like a battery. He's attaching it in front of the bus.
So, Mr. Little, do you recognize, do you recognize
Pause.
that person on the video?
Yes, ma'am.
Who is that?
That's me.
And is that your bike?
Yes, ma'am.
So the car battery shaped item is actually a ammo can box, and it is sitting right in front of the driver's window. It's metal, it's big, it looks heavy, and it's right in front of her window. She's worried that it might blow up or something. And it also blocks her view. It's like right, it's blocking half the view.
That the bus driver got off the bike. I mean, the bus. Is this a stop where the bus driver takes a break?
I guess this would be, yeah, where you would consider what the supervisor mentioned as a time point. So they get in whenever they get in, and they usually have anywhere from a 5 to a 15-minute layover before the next bus.
This is to give them time to go to the bathroom.
Exactly. Exactly. And to account for, as Mr. Rose mentioned, any delays along the route.
You can't pee on the bus. We learned
this is a catch-up point, so they can start their next route.
It's actually not illegal
Either
to
on the
carry
15
a
or
bus
on the half
to
hour.
carry a gun on the bus, as long as you don't do it in a threatening manner. You get on the bus.
Your Honor, I'm seeking to introduce the first video into evidence.
Go ahead. You can just go ahead and play.
Oh, please,
Your Honor, I don't believe Ms. Rowe has in fact actually offered it into evidence.
Well, it's admitted.
Doesn't matter. She screwed up. It's still admitted. It's all right. This is great. We can hear something.
Sure. Can we turn that up?
Not a battery, right? Is it a battery?
Previous one.
It's not a battery, right? No, it's not a battery. I'm just asking a question. Calm down. Calm down. Calm down and get off. Okay? Yes, I'm transferring this. I have a right to ask. Yeah. Got one round trip, Frank.
Okay, so he did ride the bus down, got off, got his bike out of a secure locker, put it on the bus, and got back on the same bus.
To the second video.
Can you make it full screen so we can at least see the driver? So we know if it's playing or not.
Seeking to admit 5 videos that are contained on this thumb drive.
My understanding that they were stipulated to, so all 5 will be admitted.
Six-foot bus you've missed. This trial is all yours. We even made a song about the bus. Attorney Rowe was attempting to get this next video to play. There should be a little bit of audio in it. She also said she's going to skip past the 15-plus minutes of them just driving down the road. One of these videos is going to be outside the bus, showing passengers getting off, and will show at one point the bus driver closed the door on the third passenger's arm. She was trying to make
was that you speaking?
Unfortunately.
We didn't hear that part.
And does this video reflect what you remembered happening that day so far?
It was just a shock. I mean,
Yes or no?
I'm right in front.
Just yes or no?
That's the video that has the woman's arm cut.
She's not complaining, why are you? Then why is that topic? Why is this topic? She's not complaining, why are you? She's not complaining, why are you?
She's not complaining. Why are you talking about the woman
So
who got her
what were
arm
you-
stuck in the door?
Did you have a listening device in your ears, Mr. Little?
I don't recall at this time.
Let me back the video up a tad. Did you just see yourself remove your earbuds out of your ear?
Yes, sir. Excuse me, Ms. Rowe.
Complaining, why are you? Get out of my body. I'm not gonna listen. I'm not listening to you. I'm not listening to you. I'm not listening to you. I need a supervisor, one location. Oh, not getting off the I'm calling. Yeah, you're right. I'm calling. Oh, civil rights. Violating civil rights. Got a bike, got on at Walmart, got downtown, put the bike on, and it has like a military box. So I asked him, he said, battery, got total attitude. Got your blood, and glad I can't hear me. And now a lady, but she's in the door on her. And I don't know what she did, guys. He said he needs to supervise here now because I'm violating civil rights.
I'm violating his civil rights. She's calling the supervisor right now.
Now, when you indicated to the bus driver that she was violating your civil rights, was that as a response to her ordering you off the bus?
Yes, ma'am.
Are you ready to acquit Mr. Little? Yeah, it sounds like this was more retaliatory for him saying, hey, you just slammed the door on that lady's arm. You're a terrible bus driver. I think the jury's going to get a taste of Mr. Little here in just a minute, either through video or when he wants to talk about the other things the bus driver did that were wrong, which are not appropriate for this trial. She's working on the computer. She's trying to get to the next video. She didn't make the edits. She's just trying to jump around in the video and play the pertinent parts. Yeah, and that's also, I don't think that's her computer. She's more of a pen and paper type person. I think even without these videos played, I think the first video about the...
Just wait, please.
And now,
Ms. Rowe, could you bring him the water bottle?
Your client is thirsty.
Water bottle. Whichever one's
I
Thank you.
I think this client had a good chance of being acquitted without defense presenting a case whatsoever. I think it's a little better now.
With the 3 videos we have viewed, with the 2 videos we viewed, you have, is it your understanding that that's pretty much how things have gone?
Absolutely. Except for I turned over the audio to the prosecution, and
I'm just asking you a specific question. Is what has you viewed so far, what happened?
Yes.
The audio disappeared, apparently.
Now we're going to open video 3.
I guess there's not a lot of crime in Tumwater if they've got time to devote this much prosecutorial focus on somebody not getting off the bus when the driver wanted them to. If you could just make it full screen, that would be great. Tony, thank you. We did just hit 1,000 likes. I appreciate all of you who clicked the button. That helps the channel immensely. Andrea, yes, I think this is a problem passenger. This case has been continued like 5 times, been through another lawyer. This is his second lawyer. Yeah. Even if they win this and they get a full conviction, it's a misdemeanor and a small fine. The fine is not even going to make up for an hour of the attorney's time.
So is this the time when you were trying to explain to the supervisor your version of what had happened before then?
The first thing he said is, do you want to step off the bus and talk to me? I haven't done anything wrong.
Objection, Your Honor, that was non-responsive.
Sustained.
Maybe I misunderstood the question.
Is this communication, this initial communication?
Sorry, let me put these back in. I'm sorry.
I'm sorry. Is this initial communication that you had with the supervisor in this initial communication, were you trying to explain to the bus driver what happened?
I was trying to report that the driver was using her cell phone, speeding, and failing to make a complete stop at the SPSCC.
Again, Your Honor, non-responsive.
I'll sustain the objection.
Could you repeat the question again? I'm misunderstanding.
When the supervisor got on the bus, did he give you the opportunity to explain the any communication that had occurred between you and the bus driver?
Sorry. He came on the bus and
yes or no?
He said, do you want to talk to me? He didn't say, hi, my name's whatever, and I'm a supervisor, and I'm here to, can you tell me in your own words what the problem is? He was very confrontational. First thing he said is, you want to talk to me? But it sounded almost like De Niro. You're talking to me? You're talking to me? I mean, you can't really tell because the audio is so muted from there. The only microphone is at the front. That's why I'm not going to step off the bus, because I want every word on the record.
Okay, thank you.
Bingo on De Niro.
I told her she was way on safety with a self-control speed. Every time I drive her, she doesn't, why should she? That's one of the things that comes out of the woods tomorrow. The other thing I have to mention the break, and I will make you on the internet. You cannot know what is in your bag. You can't allow her to stop. She's a reckless. You can't drive. And I told you that you see yourself. Yeah, I know. I've been writing about for 50 years. Yeah. You cannot recognize.
I've been riding the bus for 50 years. I know my rights.
Did the bus driver ever instruct you to not speak to did the supervisor, excuse me, ever instruct you not to speak to the supervisor?
Objection, hearsay. Overruled.
Repeat the question, please.
Did the supervisor ever give you instructions to not speak to the bus driver?
No,
yes
he kept
or
saying,
no?
just get off the bus.
Pardon?
He didn't say anything except get off the bus.
Okay, we're at least 3 videos through. There are only 2 left. We're almost there. I do want Mr. Little to have his chance to say his piece in court, which is going to be epic, full of objections, and nothing will be actually admissible. But I'd like him to get his say in. Deborah, he did answer the bus driver initially and said it was not a battery. And then he also said something like, it's none of your business. And she said, I had the right to ask. And it started bad there. Then after that, the bus driver closed the door on a passenger's arm that was trying to exit the bus. And Mr. Little brought this fact to her attention, probably not in the softest, gentlest way. And that was the last straw for the bus driver. And she said, get off my bus. I don't want you here. And he said, you can't make me. I know my rights. Call a supervisor. She called the supervisor. Now, up to that point, Mr. Little may have been right. But in everything that happened after that, he may have actually been wrong and thus committed the very offense that he was protesting, saying he didn't commit. I think he's guilty. I think Miss Rowe would be interested in a pro bono tech support individual helping her with her cases if you're in the area and have the ability. Still waiting. Something's playing. It's very choppy. The audio level is lower than the microphone cutoff for the pickup. So only the loudest portions come through on the microphone. Presumably the jury hears it a lot better than we do. No verdict in the Collin case. We'll be back at 8:30 tomorrow morning to continue deliberations. They've deliberated for 4.5 hours, almost 4 hours and 40 minutes. Is the driver Mrs. Little? No, no relation. Not related at all. We have been assured that that Ms. Rowe, the attorney for Mr. Little, is skipping the irrelevant parts of just bus driving footage. But I can't confirm that with the long lulls we're seeing. I can't imagine this is Mr. Little's first foray into the world of courts. I'm willing to bet that he's probably filed civil suits previously to this. There must be something up in the water in Washington. This jury sequestered. They might feel like it. It was supposed to be a one-day trial, but it's taking longer. We have the best water. This is in Tumwater. Tumwater is in Thurston County, Washington, not far from Olympia. You have good water, yeah. I'm not saying it's bad. I'm just saying, is there something in it? I do think that in a lot of areas, individuals in the homeless population seem to have more run-ins with the law. They get pushed around more. They get challenged more. They're out and about in places where the police are, looking to do some investigating. And sadly, I think the occurrence of crime is much higher in that population as well, both in the victim and the perpetrator categories. So yeah, I'm sure he feels that in life he's been pushed around, and he's had to defend himself legally from somebody who did something that just wasn't right or fair. And he might be right. You gonna send me some water? Tum water, thirst on, yeah. $6 you burned the bacon? That is a capital offense. You can't burn bacon. Bacon's so good. Dr. Bullbutter, we're at a lull right now while the jury is watching videos of buses driving. Imagine the gripping footage of a security camera posted inside the cab of a bus as it completes its regular route. The jury's viewing this at this time with virtually nothing else to separate it from any other bus footage you might find on YouTube. Amber, rough day at the job. I'm sorry. Once this completes, we're going to have some very interesting, probably additional questioning of the witness, and then cross-examination, which could be incredible. Why is no one speaking? A video is playing in court. 5 of them, actually. We've watched 3. We're somewhere on either 4 or 5 right now. Sadly, I think we're on 4. Misro was trying to fast forward through the parts that don't matter. Yes, both are on the schedule tomorrow. The Boswell trial, they have seated a jury. They have sequestered the jury and have already announced that they will be working weekends, meaning Saturday is on the table. So long weekends for us. Did Mr. Little waive his right to a speedy trial? He's been slowing this whole process down. So he's been dragging this out and causing continuances. Yes, we'll keep an eye on Griffith and then go to Boswell so we can get the openings for Boswell. And then if Griffith comes back with the verdict, we'll interrupt Boswell to take the verdict. It's going to be a lot of whiplash tomorrow, a lot like today. But be mindful. The Boswell trial has very heavy facts. Think Letitia Stout type heavy. This is a tough case with a lot of interest in it, and we would like to follow it. Be mindful that this might not be the case for everybody to follow, and I understand that. And some people have expressed that this is one they're going to sit out, and I completely 100% respect that. And that applies to mods as well. I know some of the mods, this might not be one that they feel that they can be with us with, and I 100% support them in that. Groovy Cheryl, there is audio, but the courtroom is using Zoom. The mics are controlled by Zoom, and Zoom has what's called a low pass, like a cutoff. So regular courtroom noise, just that hum and the bustle of a regular room, that falls below the threshold, the volume level that Zoom says anything above this will transmit. And so all the quiet stuff, like a quiet video where somebody isn't yelling right in the mic, it sort of just gets clipped off by Zoom. So in court, you might be hearing people talk, but on Zoom, it doesn't make it past that threshold. Yes, group hugs daily, crucial. Amber, our next trial is a very tough one, the Boswell trial. Do I use OBS? I do not, 60 Insane. I've used OBS in the past, and I have to say I don't like it, but part of that was stemmed from the fact that I use Macs, and Macs and OBS do not work as well as PCs and OBS do. I use hardware, so I have physical switchers that run my encoding instead of having a computer do the work for me. So I've got switchers and audio recorders and stream decks and all that.
Moving to admit that. Yeah.
I think they've already been admitted.
Thank you.
Clarify, Your Honor, I believe that's Defense Exhibit 2.
Okay.
That's correct. It was marked Defense Exhibit 2.
Okay, hopefully we're done
So,
with the
Mr.
video.
Little, after viewing the videos, would you say this is a pretty good representation of what happened that day?
It's prima facie.
It's prima facie.
And
He's using his law words.
in looking at the videos, it looks like you had 2 instances of communication with the bus driver. Is that what you saw also?
That's what I recall.
The first incident of communication with the bus driver was regarding the box that was on your bike.
Yes, ma'am.
And we viewed the video and saw the bus driver ask you whether that was a battery in that box. Is that correct?
It's correct.
And when she asked that, you gave her an answer.
This is the same size and shape as a battery too, but I'm not going to mistake it for a battery.
So when she asked you, you did give her an answer.
Yes, I said it's a box. I keep my lock. I mean, you can't hear in the video because we're talking over each other, but my words at the time were, it's a box. I keep my lock and my, I got a few small bike tools in there and a bottle of water. It's a part of a box. But I made that very clear, I believe. If you actually, I can't hear it very well, but if you turn it up louder, I think you can probably make that out yourself. Anyone can.
And this was when the bus driver initially told you you could get off her bus. Is that correct?
Yeah, that passive aggressive, irrational, calm down or get off my bus was miserable. I believe that the legislature.
That's the only question I'm having right this second. Let me write down your answer.
Yes. Okay. Next question.
Now, when the bus driver told you to get off her bus, did you respond to that threat?
Yes.
Now, the second incident of contact with the driver, it appears this happened as you were watching 3 passengers in the back of the bus exit the bus.
Yes, ma'am.
And what did you see when the passengers were exiting the bus?
Well, it's not uncommon. It happens more than you think. But I think the earlier testimony was that occasionally drivers close the door too early. I think it was his testimony, if I recall. And that's what happened here. But it took me off guard. It's actually the first time it happened right in front of me. And I said, you just closed the door on that lady's arm. And I blurted it out. And obviously, in hindsight, now that we're in this position.
So, Mr. Little, what was the person's reaction who was being caught up in the doorway?
Well, I looked out the window and I saw her. I assume it was her significant other. It was a male, approximately the same age, and he was questioning her because if you actually watch part of the other camera angles on the video, you could see that he turns around and he tries to console her, and apparently they're talking about what just happened, and but she seems to kind of gloss over it. They stood there on the sidewalk and spoke for 15 or 20 seconds or so. I mean, in my recollection, and then they both walked away, but they weren't. I mean, I was really hoping or assuming that.
Mr. Little, you've answered my question thoroughly. Thank you. So when you addressed the bus driver and informed her that you closed the door on the passenger's arm, we saw her response, did you not?
Yeah.
And her response was, she didn't say anything about it, so why are you? Is that correct? Yes or no?
Yes.
Yes or no to her own witness. Just answer the
And
question.
I believe that once she indicated she didn't say anything, meaning the lady who got off the bus.
And Your Honor, I'm going to object to cumulative evidence at this time. The video's just been played for the jury. They're going to have the ability to watch it. We don't need the witness to testify about what was said in the video.
I'll sustain the objection. You can move on.
Sloth Life, thanks for the 5
After
gifted
you
memberships.
notified the driver that the doors closed on the lady, did you, it appears, did you?
Mr. Rowe, am I not allowed to give my impression of what I saw in the video?
You need to stop. Let her finish her question, and then you can answer.
The witness
Go
is
ahead, Ms.
objecting
Rowe.
to his own attorney.
You can repeat your question.
When you notified the bus driver that she had closed the lady kind of in the door before the lady was completely out, the bus driver did respond, did she not?
Yes.
And by responding, did her response elicit a subsequent response from you?
I wouldn't quite say that's accurate, but I think I am the one that initiated things when I said, so you admit you closed the door on that lady's arm. She wasn't taking responsibility, and that's what I thought was so incredulous.
I was the one that
She didn't even bother to open the door and say, are you okay? You know, I mean, sorry.
Josh, thank you so much.
That's what I thought needed to be
Huge
recorded.
super chat.
And was the bus driver the person who elected to call her supervisor on her own, or did she call at your request?
Objection calls for speculation. He can't possibly know what motivated the driver to do something.
I think the question was who called, paraphrasing a little bit, who called the supervisor, or whose idea was it? I'll allow him to answer. All over your objection, he can answer.
As we all viewed in the video, I requested it multiple times. I expected it. And I would say that I've done that at a supervisor's
Mr.
instruction.
You just wait for a question, then you can answer.
It's the tail end of my question, Your Honor. I have a hard time with verbal reasoning, getting the right train cards in the right order on the right track to leave the station on time. If that is any explanation.
Ms. Rowe, you can ask your next question.
Northwest, welcome.
Were these
We love this
the
court.
only two instances of communication that you had with the bus driver, the ones that we saw here during this incident?
Yes, ma'am.
He's clearly had prior encounters with bus and supervisors.
So as a result of the bus driver asking you about the what she perceived might be a battery on your bike, and you answering that question, the bus driver closing the door when the passenger was not completely off the bus, those were the two instances of conduct that the supervisor responded to. Is that correct?
In my view. That's an assumption on my part.
Now, when the supervisor arrived, did he ask you what happened?
Oh, ma'am.
What did he say?
Ooh, open-ended question. Here we go.
We saw it. You want to talk to me? I believe his exact words were, you wanted to talk to me, but maybe we could turn it up and get that verbatim. But
and when he asked
earlier,
you that,
it was very confrontational, and there was absolutely no customer service, no introduction, I don't know who he is. I mean, I don't know him from Adam, to be quite frank, or what his position is with the company, whether he even has the authority to do anything.
So he didn't identify
no former knowledge of that.
He didn't identify himself?
No, ma'am. He didn't say his name, his job title, his anything.
Did he have any badges on?
No, I think if you look at the video again, he might have a shirt with intercity transit labeled, or, but I don't recall. Some drivers wear, or some supervisors wear that. I don't recall whether he was wearing that particular day or not.
So since you were the person who asked for the supervisor to come to the location, when he arrived, did he ever ask you why you requested the supervisor?
Not once. I requested a supervisor because...
Mr. Little, I haven't answered you.
I haven't asked you another question.
Did he ever notify you of any specific conduct that he believed you had engaged in that was unlawful?
He said that I was yelling at him, and I told him that I had a hearing damage, significant hearing damage. And I've also made comments to the management of intercity transit that there are announcements on the bus. I have a decibel meter on my telephone, and everything over 85 decibels is, I've done industrial work, and,
you have hearing loss.
Yes, ma'am. I mean, I was a quality control inspector and welder and machinist. So I worked in a lot of really loud industrial environments, besides going to Ukraine for 6 months and being on the front line. And I'm not going to finish that.
So did the supervisor ever notify you?
But my point is, I didn't finish my
You
answer.
answered my question, Mr.
No,
Little.
I didn't. Because when you asked me about the hearing damage, I told him that the announcements on the bus are only a couple of points less than the 85 decibels. My voice, my speaking voice, isn't any louder than the announcements on the bus. And I can show you. In fact, I took out my phone, I believe, and if we look at a different video, I took out my phone and said, I showed him the actual numbers because it was picking up just the way this microphone is picking up, but it was giving it a calibrated scale.
Okay, so Mr.
How
Little,
loud my voice actually was, and my voice did not exceed the announcements on the bus.
Understood. Very, very much understood.
Now I might be, I don't know.
Did the supervisor ever tell you that it was unlawful for you to tell a bus driver that you perceived she closed the door on a passenger who had not fully exited?
Objection, Your Honor. It calls for a legal conclusion from a witness who's not testifying.
Sustained. You can ask your next question.
Did the supervisor ever inform you of any conduct that occurred before he arrived that was a violation of any policy?
No, the only thing I remember strongly was him asking me multiple times, just get off the bus. And I felt like he was trying to isolate me from the recording devices, which I felt were my protection in asserting, not aggressive, being assertive in claiming my civil rights. The legislature says that I'm entitled to full enjoyment. I'm entitled to full enjoyment of the bus. And anything else, unless I've done something wrong in my reading of the law, is a violation of my rights.
Jury's hearing it
And you
now.
tried to explain that to him?
Multiple times. I mean, I
Did
told him where
he
to find it in
engage,
RCW.
did he accommodate you by listening
No,
and
he didn't
responding
listen to a
to
word
your?
I said. Just get off the bus. It's not a violation of your civil rights, he said.
He's doing the voices.
That was the officer.
That was the officer.
Did the bus driver ever tell you to cease any conduct?
I don't recall any. But the video speaks for itself.
I do want these charges thrown out now. I really do. I think it's absurd that the city is pursuing so aggressively such a minor situation.
Did the supervisor ever instruct you not to speak to the bus driver at all?
No, ma'am.
Here's,
And we heard the testimony
hang on,
of
I'll wait for my
Mr.
turn.
Rose earlier. And I'd like to review a couple of things with you.
I would be okay with him being convicted and also winning his civil suit. That's where I think I'd be okay with. Because, yes, I think he is right. He did.
Do you remember when
violate the rules.
Mr. Rose indicated in his testimony that transit authority are not just going to order someone off without assessing the situation?
Your Honor, objection, relevance of his knowledge of prior testimony?
Ask it again. Judge, you weren't paying attention, and neither was I. Ask one more time.
We're going to take a break here right now. I'm going to send you back into the jury room. And then we're coming up on, why don't we go ahead and take our afternoon break now? If you need a break for the restroom or something like that. So we'll be on a break for 15 minutes.
The judge is like, I thought this was going to take 20 minutes. Let's see if they kick us out promptly right now, or if they leave if we have a discussion first.
Where exactly are you headed with this?
I am reviewing the state's evidence that it elicited from their witness and going to, in an effort for Mr. Little to clarify
Was not a battery, and it wasn't on the bus.
Well, I think that,
or agree or disagree with what the witness's prior testimony was.
well, I think I'm going to sustain the objection on that. I don't think it's appropriate for one witness to be commenting on the veracity of another witness. I'm not going to let Mr. Rose come here and call Mr. Little a liar. I'm not going to let Mr. Little sit here and call Mr. Rose a liar for this morning. It's up to the jury to decide, and they'll get instructed on how they decide who to believe. They heard Mr. Rose, they're hearing Mr. Little, they saw the video, and then they're going to make the determination. So I'm going to sustain the objection to that line of questioning, and you can move on to something else.
I will.
You want to take a break now?
Your Honor, may I address the court on the record?
About what?
Am I not allowed to testify about my impressions of what happened at the time? I need a ruling on that.
So you don't need a ruling. Your attorney is the one who makes the arguments. And remember what I said this morning. This is kind of what I was talking about. So the ruling I'm giving right now is Mr. Rose testified this morning. That's in front of the jury. You're testifying now. That's in front of the jury. No, I'm not going to let you give it a critique of Mr. Rose's prior testimony. You can and have been giving your impression about what happened on the video. Yes, you can do that. And I think we've kind of come to the end of that video. So that's the ruling I'm making. And frankly, I'm doing a courtesy, even responding to what you, because the arguments are made by your attorney. And I've made that ruling. So you can go back and sit with her. And then you said you wanted a restroom break. We'll reconvene. What are we saying about today? About 2:57. Why don't we reconvene at about 3:07 or 3:08?
Okay, so this will catch us up from the verdict or the question.
Just be careful around. I mean, there's jurors around there. They might go to the restroom as well.
Don't talk to them in the bathroom. Please don't talk to them.
Yeah, just you can go sit with Ms. Rowe for right now, and then when they wait a minute or two to let them come back, and then you can go to the restroom. I'll be back in a few minutes.
And Your Honor, I'm going to step upstairs and take a phone call for the office.
They expected me to be done by now, and I'm going to call them and tell them why I'm not.
Because when the dispatcher said, "Are you all right to keep going?" And she says, "Yeah." Well, he says, "Okay, well, just keep going, and I'll have a supervisor catch up to you."
Okay.
So I didn't delay anything.
No.
They could have kept going at any time. In fact, they did.
They did. We can see that.
But we need that audio on there to impeach what you heard from the driver. You heard the driver's section, but you didn't hear what the dispatcher told her to do. And it blows a big fat hole in the prosecution's case, saying that I delayed the bus. That's the whole basis. I didn't delay the bus, but the dispatcher said, "Just keep going."
We heard the bus driver. We heard the bus driver say,
"That's my point.
That you can just meet me when we get there."
And here's the other thing. In my notes, Mr. Rose says that.
Now, you know this trial will not be decided on what the dispatcher told us. The trial is about your conduct and your conduct only.
They're in court. The clerks are there. They're talking at full
So what
volume.
were you going to say?
I was going to say that I barely get a word in edgewise sometimes. And it's very frustrating.
I can barely get a word in edgewise sometimes.
Because I lose my train of thought. And
the jury is not hearing this.
in the thing, he says, "Are you able to keep going?" Rose says, "Are you able to keep driving?" Okay. He said he's heard all that. Okay.
This is a hard thing for
You
people
have
to.
your computer with a zip drive that I gave you that had the audio on it, because that audio was on the one I gave you too. Did you delete that one?
I'm not sure, Mr. Little. Whether
He said that his main concern is safety. And if his main concern is safety, then how in the world, this is your closing argument.
Absolutely.
If the main
It was
concern is safety,
clear
then
from
how
the
in the world
video
did you
you
not
didn't
take a complaint
create
about
a-
cell phone use, speeding and failure to stop and everything else going wrong? Because you think that that's only applies to the civil. And that's the basis of my complaint.
No. So let me explain to you. We'll have to wait until the judge.
Okay, they fixed it. All right. So now we get to the next part, which is about to start. It's difficult for somebody who doesn't understand the rules of evidence to figure out what you're allowed to say and what you're not allowed to say, and it's hard for people to grasp and understand the fact that there are things that happen in surrounding the event in question that are not allowed to go in front of the jury. And to you, it's like, well, that explains the whole situation. That's the background. And the rules of evidence are clear. And some things cannot come in. Some things can't come in because it's hearsays. Some things can't come in because it's it's not relevant to this. Some can't come in because it's too prejudicial. There are a lot of rules at play, and it sounds like Mr. Little does not understand what those limits are. He wants to tell his whole story. He wants to litigate the civil suit right in the middle of the criminal suit and not separate the two. But the criminal suit is saying, you, Mr. Little, in this whole occasion, did one thing that was against the law, and you violated the bus transport guidelines. I forget what it is, but your behavior on the bus was grounds for the bus driver to kick you off, even if it started from something that was not your fault. It rose to the point where it became a problem. Legally, they could kick you off and you wouldn't leave. That's why we're here. And it's just that part. And that's probably why the prosecutor said over and over at the beginning, we're not relitigating the battery issue. We're not here to determine if the bus driver was speeding, if the bus driver ran a red light, if the bus driver, was, anything she did wrong. We're not relitigating that. We're just talking about this little offense. And it's very hard to separate that in his head. Ms. Rowe, props to you. This is a tough client, and she's pushing through. Mod chat, please. Let me check. Hang on 1 second. He delayed the bus system. He did. I would say the bus would not have been delayed if it weren't for that, but I also think that, what we've heard that maybe the jury did hear, maybe we didn't, because we didn't get to hear all the audio exactly. Maybe that delay was more elective by the bus driver, saying, I'd rather not drive. Well, this is the case. I'll sit here and wait instead of following the dispatcher's instructions to just continue on, and they'd catch up to them. This is a conflict attorney. Yeah, he's had like 5 hearings before. This case has been a ways in the making. Let's see. I don't think he has little understanding. He's using legal terms mostly in their proper context. He's got prima facie. He's talking about discovery. He's talking about evidence. He understands the role of the jury and what they need to hear, and making a case and closing arguments. I would say he's able to. He would probably be a better sovsit or pro se, not sovsit. No one's a good sovsit. He would be a better pro se than many pro se defendants we've seen in court. How many people were on the bus? 2 others were on the bus when this happened that were still on the bus. Some got off during it. I think 3 got off at the time that the bus driver closed the door on the lady's arm, and there were still 2 remaining when the supervisor arrived on scene. Okay, okay, I just saw the mod chat. So clearly I read the wrong thing. Let me take care of that one for you guys. It's just going to be a moment more before we're back in court, I think. We had a little bit of a delay because we paused to go watch the happenings in Florida live. It is just after 6 p.m. on the East Coast. This court we're following is on the West Coast in Washington. So they've got a few more hours of work yet ahead of them. Mods, I think it's taking care of itself. All right. Red Pen, I am trying to get away from the actual thumbnails on the channel and do YouTube. YouTube keeps beating me about the head and shoulders about my thumbnails and saying I need to do a better thumbnail. So I'm trying to do better thumbnails. I'm not adverse to doing a poster for a trial to sort of memorialize a lot of the occurrences of the trial, the happenings, who testified, what they said, some funny things that might have come up, what we're counting in the trial, all that. But for having it be a thumbnail in the video, we are going away from that. I did eat today. My son made me macaroni and cheese, and when I cut the camera to show the back view in the corner, so it showed my desk, that's when I was eating. Hopefully, I muted the mic as well. Need some Mr. Beast thumbnails. Mr. Beast, I believe, and Mr. Beast and like Dude Perfect both use AI to modify images. So it looks like a real picture, but it's been modified by AI to give it just that little, I don't know, like a cartoon style edge. Jackie says it was the thumbnails that brought me here. We'll still have some thumbnails. We won't be all done. It's just this particular court is a little bit too quick to devote a lot of time to a thumbnail. Okay, it looks like they're going live right now. Let me see where it's at.
Assess the situation.
Objection.
Did he adequately assess the situation?
Objection.
Sustained.
Okay. I guess we're back. They just started.
Mr. Little, what is
He's back on the stand.
your understanding of the rights that passengers have in using public transit?
Objection. Calls for legal conclusion that he's not qualified to answer.
What's your
I'm
understanding?
going to sustain it also on relevance grounds.
Mr. Little, were you afforded the opportunity of full enjoyment of your ride, of the ride on the bus that day?
Absolutely not. The reason I use the term full enjoyment is because that's what the statute reads.
Ooh,
at the beginning of the chapter.
So it is. So you believe you were not afforded full enjoyment of your bus ride that day?
Absolutely not, Your Honor, Mr. Rowe, because the legislature started off by saying this is civil rights, okay? And then the next chapter, they talk about...
Sustain the objection. You can stop, and then Ms. Rowe, you can ask your next question.
Have you had a chance to review the policies and procedures required in order to order someone off the bus?
Objection.
Sustained.
Your Honor, may I confer with my attorney?
She can continue.
Mr. Little, when the supervisor contacted you on the bus, were you yelling at him?
No more than I was yelling in court.
So that is a yes or a no.
Is that a yes?
I think that's subjective to the point to where I have ringing in my ears all the time. What I can hear is much different than what you can hear. I hear a lot of ringing, and I have to overcome that in order to hear myself, especially if I'm trying to hear myself over someone else. And
so does this cause you, does your hearing impairment cause you to speak in a loud tone?
Ms. Rowe, that's for everybody else to answer.
I'm asking you.
Well, I believe, yeah, based on the input that I get from them, that I don't have to talk so loud. That's why I carry that decibel meter, to keep an eye on it, to say, okay, well, here's the numbers. Either yes, I was, or no, I wasn't.
And is that the reason why you are also wearing a hearing device during the duration of this trial?
Yes, ma'am.
And that's based on your hearing impairment?
A lot of damage, yes, ma'am.
Did you
I've got tinnitus.
harass the bus driver?
Objection calls for a legal conclusion.
I'll overrule.
He could be.
If my demeanor is demonstrative, I think, again, that's subjective, but I didn't use any foul language. I didn't use any pejoratives. I didn't, call anybody names. I didn't use profanity. My argument to both the officers and the supervisor was logical. It was rational. And I was asserting my civil rights. Tell me what I did wrong, except just trying to assert my civil rights. If that's,
Okay, you need to stop, and then Ms. Rowe is going to ask you a different question.
Just trying to finish the question before, Your Honor.
Were you aggressive towards the bus driver?
No, ma'am, not in my opinion.
This part doesn't matter much in the criminal suit.
Rough crowd for too many years.
It does matter more so in the civil suit, or could be more pertinent.
So you were not aggressive to the bus driver?
Not in my opinion.
Not harassive to the bus driver? Answered her question regarding the battery?
Logically and succinctly, with no ambiguity.
It's got good vocabulary.
You informed the driver of the door closing?
Yes.
And as a result of those 2 points of contact with the bus driver, you were arrested?
Yes, ma'am.
In fact, let me back up. As a result of the 2 instances of communication with the bus driver, you were first ordered off the bus by her. Is that correct?
Multiple times.
That's where the problem lies.
Before we ever
Then
left.
you were secondly ordered off the bus by a supervisor.
Yes, ma'am.
Right here, Ms. Rowe is about to convict her client.
And lastly, you were ordered off the bus by law enforcement.
Yes, ma'am.
Done. Guilty.
And is it your understanding that you were ordered off the bus by the state actors for invoking your civil right to enjoy the full enjoyment of your bus drive?
Objection, facts not in evidence, misstates the law.
I'll sustain the objection, and it's a leading question as well.
The judge adds his own objection. Okay, you're guilty as charged, but you still have a civil suit that you can win. The burden is different on a civil suit, and the
As
focus
a
is
result of you and being ordered off the bus, was your subsequent conduct an invocation of what you believe to be your civil rights.
I'm sorry, could you repeat that?
As a result of being ordered off the bus, was your subsequent conduct an invocation of your civil rights?
Yes, ma'am. That's the only conclusion I can
One
reach.
last question, Mr. Little. Are you aware of what date is it today?
Today is the 4th of February. Ironically enough, it's a day we celebrate.
Objection, Your Honor.
Sustained.
That's where she was going with this one.
And is February 4th significant in relationship?
Objection, relevance.
Sustained.
If I could finish my question.
You can finish your question.
And then I'll
Is
sustain it.
February 4th significant when it comes to intercity transport?
Objection, relevance. Today's date has no relevance.
Objection. That's.
I have no further questions.
All right, here comes
And
cross.
Mr. Thompson, you may cross-examine.
Thank you, Your Honor.
This might get spicy.
Mr. Little, multiple law enforcement officers approached you on the bus on June 10th, 2024, correct?
Correct.
That was in Tumwater, Washington?
Yes.
Okay, and those officers had a conversation with you for a number of minutes, correct?
Correct.
And they informed you that you needed to get off the bus, correct?
Correct.
And you refused to do so, correct? Let me ask it again. Did you refuse to get off the bus when directed so by law enforcement?
Yes.
Okay.
There's
Now,
the elements of the crime.
Mr. Zachary Rose approached you on the same day prior to law enforcement contacting you, correct?
Correct.
And he asked you to get off the bus as well, did he not?
That's correct. He asked me to get off the bus.
And you refused to do so.
That's correct.
Now, Mr. Rose went so far as to not only ask you off the bus, but he also added that you were more than welcome to take the next number 12 that was less than 30 minutes behind you, correct?
That was a punitive action, not a benefit to me.
Let me rephrase the question because it doesn't seem like you understood it. Did Mr. Zachary Rose offer you an opportunity to ride the number 12 that was coming
It
next?
was not a genuine offer. No.
Did Mr. Rose offer you to ride the number 12 that was coming behind the one you were currently sitting on?
Asked and answered.
Your Honor, I would ask the court to direct the witness to answer the question.
So,
The judge.
I'm not going, how can I phrase this? I'm going to allow, no objection was made to that question. And so I'm not making a ruling, but I'm going to allow Mr. Thompson to re-ask his question, and then you can answer it as best you can.
Thank you.
Ms. Rowe was supposed to object.
Mr. Little, did Zachary Rose offer you an opportunity to ride the number 12 that was coming behind the one you were sitting on?
I have no complete clear recollection unless we could play the video again with the sound loud enough where I can hear it. I don't recall exactly the verbiage that was used.
Then why did you just say, well, it's punitive? So you clearly...
Because everybody's trying to kick me off the bus.
Okay.
They're trying to get me off. I got a broken bike. I'm trying to get home, limp home. And they're just trying to kick me off because that's how they punish people.
Mr. Little, I asked you if he offered it to you, and your response was because it was punitive. So that implies that you did hear the question from him because you formed a conclusion about that question. So I'm going to ask again, did Mr. Rose offer you an opportunity to ride the number 12 behind you?
Yes, he did.
How long would you estimate between Mr. Rose getting on the bus and the law enforcement arresting you, you guys sat there?
I have no idea, but we left late. That's within the video too, but nobody pointed it out.
15 minutes?
I have no idea. It's actually on the video. We can look at it for certain. My opinion doesn't really matter. It's a hard number, and the prima facie evidence is right there.
Okay, so looking at the defense exhibit 2, there's 5 videos on this thumb drive. Here's timestamps. So the last video is about 6 minutes long, and the video just before that is 5 minutes long. Now, the second to last video Miss Rowe played for you, that was the video where you and Mr. Rose were having a conversation, correct?
Correct.
And the last video is where you and law enforcement having conversation, correct?
Correct.
So in total, that was about 11 minutes. And the other video, which is about 7 minutes long, video number 3 on there, that's the first time that you and Mr. Rose have a conversation, though, correct?
I don't recall the order.
So in grand total, though, we're looking at somewhere in the ballpark of 15 minutes. Is that a fair assessment?
Yes, I think so.
Okay.
Both text me on
And
the
you were
burner
asked
phone,
by more
please.
than one person to get off that bus, correct?
Warrior Queen and Bug Dugger both text me.
You spent a lot of time discussing the person who, as you phrased it, got caught in the door, but their arm didn't actually get caught in the door, correct?
Absolutely not. Her arm was clearly in that door. You can see the door actually stop motion before it comes back together after she pulled her arm out. Look at it closely. I was there this feet, 4 feet away.
And you're not a lawyer, correct?
No, I've not taken the bar exam.
Did you attend a law school?
Objection, Your Honor, relevance.
You spent a lot of time discussing the laws.
Sustain the objection.
It's getting personal there.
Your next question.
Now, you asked, or you proposed a courtesy ride to Mr. Rose, correct?
Incorrect. He was the one that offered that. It's on the video. And I told him, can you take my bike? The one that you saw, that Miss Rose, or excuse me, that Miss, my lawyer, sorry. What's your name again?
Ms. Rowe.
Miss Rowe. Called you Rose for a second.
Sorry.
I couldn't
That's
make
funny.
a connection.
My lawyer. What's
If you look at the video and rewatch it again, you will see that he said, I can give you a ride. I said, and he offered that. He said his testimony was that he tries to do that. He did. And I said, I got a bike on the front. Can you take? No, I can't take your bike. It's like, can you just follow the bus to Walmart, which is only a mile away? I mean, but the audio evidence that I gave you from the dispatcher.
And Your Honor, objection.
Staying.
So you never proposed a courtesy ride.
I did secondary after his initial offer, and then retract the offer because he couldn't take my bike. And then I said, in the presence of everyone, not just the supervisor, if you can give me a ride and take my bike, which is broken, which I can't ride. I mean, we're only a mile from where I sleep. I said, all you got to do is give me a ride. Just, I can ride in the supervisor's vehicle, follow the bus a mile to Walmart to get off my bike.
So you were willing to get off the bus?
I was willing to get home in an expeditious manner as quickly as possible. If that would get me home instead of sitting there waiting for somebody to violate my civil rights, I'm happy to do that. I'm just trying to get from point A to point B with as little, nonsense as possible.
So again, I would ask, you were willing to get off the bus?
I was willing to get home. If that would get me off the bus, getting off the bus was not the issue. Getting home in a timely manner was the issue.
Mr. Little, I'm going to ask it as a yes or no question because that's how I've asked it. You were willing to get off the bus, correct?
I was conditionally willing to get off the bus. That's correct.
So conditions on your terms and your terms alone.
In my reading of the law, I'm entitled to full enjoyment unless I've done something wrong. I said simply, tell me what I've done wrong.
But you're not a lawyer. So let me ask again.
You weren't there.
It was conditioned on your terms and your terms only.
No, it was open to negotiation. All I had to do was get me home. It was a simple thing. Just give me a ride, and we're only going a mile, and I can take the bus, or take the bike off the bus as soon as we get there. It was a simple solution that I mean, if you base it on his testimony here that he really goes out of his way to try and.
Mr. Little, I'm going to ask
Am I allowed
again.
to keep the, you know?
Okay, so just, you can ask your next question, and your attorney will have a chance to ask you questions following Mr. Thompson.
I would either like to finish my answer or had someone object.
So, Mr. Thompson, you may ask your next question.
If I'm saying something wrong, then he should raise an objection, Your Honor. If I'm wrong in my assumption, please correct me.
Okay, I'm just going to have you stop. Mr. Thompson, you can ask your next question.
So your condition was that he had to give you a ride with your bike. That was your condition to get off the bus, correct?
I'm not going to leave my bike on the bus.
Didn't say you had to. That is correct. Mr. Little, is that correct?
Please restate your question.
Your condition for getting off the bus was the supervisor had to give you a ride with your bike. That was your only condition to get off the bus.
No, you're characterizing this completely wrong. I didn't make any demands. I was just trying to get home. I wasn't making any demands of anyone.
So when the jury...
I'm trying to look for a solution. If you can give me a ride home and still just drop off on my bike, I'm happy with that. I'm wasting time here. I got a lot of stuff to do. I walk 200 miles a month besides taking the bus for 80 hours a week. I mean, I'm on the bus a lot. Maybe 80 hours a week is an exaggeration, but I've logged it. And I'm telling you, I'm just trying to get from point A to point B. It takes me 2 hours to get up in Tumwater, to go downtown to take a shower and then come back on the bus. So I'm just trying to shorten that up as much as possible. Otherwise, I get nothing done in any day, and I'm retired.
Do you believe that if you'd just gotten off the bus when Mr. Rose asked you to and taken the next number 12, it would have been quicker than arguing with Mr. Rose for 15 minutes and law enforcement for an additional 10?
Objection, Your Honor. Calls for an opinion.
Sustain. You can ask your next question, Mr. Thompson.
If you were interested in going so quickly, why did you not get off the bus when requested?
Because I'd be stranded. I can walk home that fast.
The number 12 runs the same route every day, correct?
Yes.
And so a number 12 was coming shortly thereafter, was it not?
A half hour.
Okay. And you didn't want to wait half an hour?
I didn't do anything wrong. Why? Why wait a half an hour when I'm innocent?
You were asked to get off the bus and you didn't want to wait a half hour, correct?
Your Honor, that's asked and answered.
Amen.
No
I'm
commentary.
going to allow you can give an answer to that question. And you can repeat the question if you need to.
Please.
You did not want to wait half an hour, correct?
Absolutely not. Not another half hour. She was already late leaving. And the time that she spent arguing on the way affected the schedule just as much as me asserting my civil rights. Look at the video. She was late leaving. There's a beeper that you can hear, an audible beeper, beep, when they're supposed to go. She wasn't even back in the bus yet. I mean, at least half the delay that you're trying to pin on me is from the driver who talks on her phone, speeds, and fails to make complete stops on a campus, a college campus, with nuthead teenagers running around.
No further questions, Your Honor.
Bingo on the method.
Ms. Rose.
Thank you, Your Honor. Mr. Little.
Yes, ma'am.
Before the supervisor or law enforcement got involved, did you hold up the bus?
No, ma'am. In fact, the dispatcher told the driver to keep driving. That's in the audio that I provided to the court, and
Mr. Little,
it hasn't been played in court.
Mr. Little, I understand that this is your day in court, and I understand that you want to be on a truth finding.
Objection, Your Honor.
I understand.
Sustain. You can ask your next question.
Mr. Little,
Yes, ma'am.
Did the supervisor contacting you hold up the bus?
No, ma'am. The dispatcher told him to keep going.
When the supervisor arrived and the communication that you had with the supervisor, was it the supervisor's conduct of questioning you partially what held up the bus?
Objection, Your Honor, invades the purview of the jury. The jury's the fact finder.
I'm going to sustain the objection as to the form of the question.
The supervisor offered you a ride, correct?
Yes, ma'am.
But that ride was not feasible because you couldn't also take your bike. Is that correct?
He withdrew the offer when he found out that I had a bike.
The ride was not feasible because you had a bicycle, correct?
Yeah, he said he couldn't do it. He testified that in court. He was driving not a pickup, he was driving a SUV. And that's why when the instance that you pointed out, when I walked up to the front, I said, look, all you got to do is give me a ride and get my bike there too. As long as you can get us both there, I'm happy. I was amenable. I mean, I was trying to find a solution that didn't violate my rights and didn't delay me any longer than I had to be with a broken bike and a lot of other things happening. Just trying to get home.
If the situation weren't so sad, I would
Is
play
the
sad music
reason why you refused to get off the bus when the supervisor asked was because you didn't?
Objection leading.
I didn't.
Sustained. You can ask what the reason was. Don't suggest it in the question.
When you refused to get off the bus, was it your position that you had not done anything
Objection
wrong?
leading.
So that's sustained.
Mrs. Rowe does
Don't
have
think I have
struggle to get around some of these objections.
Any other questions?
Anything further, Mr. Thompson?
No, Your Honor.
Mr. Little, you can go back to
Thank you.
counsel Davis.
All right. Are we ready for
Do
closings?
you have any additional witnesses?
I do not, Your Honor.
Are you resting at this time?
I am, Your Honor. Thank you.
So, members of the jury, we've concluded the evidence portion of the trial. Send you back to the jury room one last time. This will be shorter than the last time, I promise. Can't say how much shorter, but hopefully in about 5 minutes, we'll come back out, get your instructions from me, and then argument from counsel.
Sorry, I didn't mute myself. I'm trying to eat a salad. Mrs. R.A. brought me.
We're still in the
salad
record.
and
Ms. Rhodes, did you get a chance to review the jury instructions?
I did, and I have no objection to any of them, Your Honor.
So go ahead and ask me, go ahead and distribute to one for each for Mr. Little, Ms. Rowe, Mr. Thompson, and oh, you already did that. Are the jury instructions on the seat?
Yes. Copy of the jury instructions.
Okay. Okay, then. Well, I guess we can back. Will be a short recess. We can go ahead and bring them back in. And sure.
They didn't even sit down
Unless
yet.
unless someone wants to use the restroom or something, you can just check, see if they're ready.
Jury's coming back.
And Your Honor, how much for closing again?
What's that? 20 minutes.
20 minutes?
Yeah, 20 minutes each.
Please,
Understood.
please use one. Use one and be done.
I'm hoping that's enough time.
That's
Ms. Rowe,
You have 20 minutes.
please be joking.
Do you have a template that I could get from you?
Not right now, I don't.
No, I mean, if you could email me just a blank
What kind of thing?
legal pleadings.
Okay.
You can be seated in the courtroom.
Just ask his attorney. I'm basically going to file some motions here on this. Do you have
So
a
when you came
template?
back in, you're holding in your hand now, it says court's instructions to the jury. I'm going to read them to you, each one. And I've learned and observed over the years, different people have different listening or learning styles. Sometimes most people follow along as I read them. Some people step to the side and listen. Whatever your particular style is fine with me. But the law that will apply in this case is as follows. Instruction number 1. It is your duty to decide the facts in this case based on the evidence presented to you during this trial. It is also your duty to accept the law for my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law for my instructions to the facts that you decide have been proved, and in this way, decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true, and your decisions as jurors must be made solely upon the evidence presented during the proceedings. The evidence that you are to consider during your deliberation consists of the testimony that you have heard from witnesses, stipulations, and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You're also the sole judges of the value or weight to be given to the testimony of each witness. And in assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things that he or she testifies about, the ability of the witness to observe accurately, quality of the witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome of the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statement in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you, and you must disregard any remark, statement, or argument that is not supported by the evidence or the law and my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on a lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during the trial or in giving these instructions, you must disregard this entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions, and during your deliberations, you must consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process, and you must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. And to assure that all parties receive a fair trial, you must act impartially and with an earnest desire to reach a proper verdict. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based on further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charged. The state is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. The defendant is presumed innocent, and this presumption continues throughout the entire trial unless, during your deliberations, you find that it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction number 4. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case, and one is not necessarily more or less valuable than the other. Instruction number 5. The person commits the crime of unlawful transit conduct when he or she, while on or in a transit vehicle or in a transit station, he or she knowingly obstructs or impedes the flow of transit vehicles or passenger traffic, hinders or prevents access to transit vehicles or stations, or otherwise unlawfully interferes with the provision or use of public transportation services. Or a person also commits the crime of unlawful transit conduct when he or she unreasonably disturbs others by engaging in loud, raucous, unruly, harmful, or harassing behavior. Or a person also commits the crime of unlawful transit conduct when he or she engages in other conduct that is inconsistent with the intended use and purpose of the transit facility, transit station, or transit vehicle, and refuses to obey the lawful commands of an agent of the transit authority or a peace officer to cease such conduct. Instruction number 6. To convict the crime of unlawful transit conduct, each of the following elements of the crime must be proved beyond a reasonable doubt. 1, that on or about June 10th, 2024, the defendant, while on or in a transit vehicle or in or at a transit station, he or she knowingly obstructed or impeded the flow of transit vehicle, hindered or prevented access to a transit vehicle, or otherwise unlawfully interfered with the provision or use of public transportation services, or unreasonably disturbed others by engaging in loud, raucous, unruly, harmful, or harassing behavior, or engaged in other conduct that is inconsistent with the intended use and purpose of the transit vehicle and refuse to obey the lawful commands of an agent of the transitory authority or a peace officer to cease such conduct. And 2, that any of these acts occurred in the city of Tumwater, Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 7. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result. When he or she is aware of that fact, circumstance, or result, it is not necessary that the person know that the fact, circumstance, fact, circumstance, or result is defined by law as being unlawful or an element of the crime. If a person has information that will lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted, but not required, to find that he or she acted with knowledge of that fact. When acting knowingly is required to establish an element of the crime, the element is also established if the person acts intentionally. Instruction number 8. The person acts with intent or intentionality or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 9. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You are all officers of this court, and you must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken to the trial. During trial, if you wish, you've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more accurate or less accurate than your memory. You will need to rely on your notes and memory as to testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after carefully reviewing the evidence and instructions, you feel the need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly, and for this purpose, use the form provided in the jury room. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the clerk, it says bailiff, but in our case, clerk, and I will confer with the lawyer to determine what response, if any, can be given. You will be given the exhibits admitted into evidence, these instructions, and a verdict form for recording your verdict. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank and provide in each verdict form the words not guilty or the word guilty according to the decision you reach. Because this is a criminal case, each of you must agree for you to return a verdict, and when all of you have so agreed, fill in the verdict forms to express your decision. The presiding juror must sign the verdict form and notify the clerk. The clerk will bring you into the court to declare your verdict. Those members of the jury members of the jury is the law that will apply in this case. So for the next 20 minutes, would you please give your attention to Mr. Thompson for his closing on behalf of the city of Thompson. Mr. Thompson.
Thank you, Your Honor.
Now, all the instructions that the court just gave you are important. I'm going to focus on just a few of them. One, I want you to turn to instruction number 6, if you don't mind. This is called the to convict instruction. That's us in the community's shorthand version of what the state has to prove for the jury to convict the defendant. Also, it starts with the word to convict. Makes it very easy. Now, that on or about June 10th, 2024, everyone testified that this is the date it happened. So that's what I have to prove, that this happened on or about June 10th, 2024. We have proven that. Both witnesses testified this happened on June 10th, 2024. The defendant, Mr. Little, while in a transit vehicle, you saw the video, both witnesses that testified that he was in a transit vehicle, knowingly obstructed or impeded the flow of a transit vehicle. You watched the last 3 videos that Ms. Rowe played for you. You heard Mr. Rose talk to you about how long that vehicle had to sit at that stop waiting for Mr. Little to get off. He refused to get off for about 15 minutes. That impeded a transit vehicle. Interfered with the provisions or use of public transportation services. Just a different way of saying much the same thing. You'll see that there's a little bit of overlap in all of these ors. It's different ways to look at what can very much be the same thing. Unreasonably disturbed others by engaging in loud, raucous, unruly, harmful, or harassing behavior. The state's not asking you guys to consider that one, I'll be honest. I want to make it very clear, and I thought I made it clear in my opening, but I do want to reiterate it now in my argument. The city is not submitting to you that Mr. Little's behavior towards the bus driver is what constitutes a crime. It is not his interaction with the bus driver that constitutes the crime here. Make it very clear. His refusal to get off the bus when Mr. Rose asked him to, and his subsequent refusals to get off the bus by law enforcement is the crime. When Mr. Rose got on that bus as a supervisor, what's going on? No crime had occurred yet. That's not the state's position. It never has been the state's position. He informs him, he's like, Mr. Little informs Mr. Rose, his version of events. Again, we're not here to litigate what those events were. It's not important. It's not relevant. It's never been relevant. The interaction between him and the bus driver does not constitute the crime here. It was his interaction with Mr. Rose and his interaction with law enforcement. So, a brief explanation. Mr. Rose, as the supervisor, makes a determination. I got to get this bus moving. And for the other passengers' safety, for the bus driver's safety, the easiest thing to do is have Mr. Little get off this bus, catch the next one. Is it inconvenient to Mr. Little? Sure. It would inconvenience anyone who has to wait for the next bus. But a 30-minute inconvenience, as Mr. Little pointed out, versus the bus not moving at all. We can't go anywhere. Law enforcement now has to get called because he was angry at how a bus driver talked to him. He was angry that this young supervisor came up and didn't want to hear his full side of the story. And as he keeps repeating over and over again his civil rights, you will hear nothing in your, or you read nothing and heard nothing in your jury instructions about his civil right to ride a bus. That is not the law. There is no such law. In this case, this is the law, the jury instructions. He was given an order to get off the bus and ride the next one. It is unfortunate that the supervisor in the situation had the Explorer, not the F-150. I think that's what he said, it was the F-150. And he couldn't throw the bike into the bed of the truck. And the next step was catch the next bus. But that wasn't good enough for Mr. Little. Now, Mr. Little couched this in his civil rights and his this, that, and the other thing. That's not what this case is about. He didn't like how the bus driver talked to him, didn't like how the young supervisor talked to him, and he didn't like that law enforcement got involved, and he was angry and upset. And he dug his heels in, and it was his way or the highway. Now, you are free to watch all 5 videos. It's about 45 minutes for all 5 videos. I would encourage you to focus on, if you choose to watch any of them, the last 3. And you can feel free to click around to get to the part where you're talking, just for speed up the process if you so choose. Or you're obviously free to watch it in its entirety. Again, the first 2 videos, the state is not alleging is any part of the criminal conduct. That's his interaction with the bus drivers, or with the bus driver, not part of the criminal conduct. It's what makes him angry, sure, but it's not what constitutes the crime.
Not today, Josh, not today.
The other jury instruction I like to point out is what I have just said and what we'll finish saying here next couple minutes. What witnesses have said, what Ms. Rowe will say. None of that is law. The law is here. What I say and what Ms. Rowe says are not facts. The facts before you that you have to determine are the facts of this case came from the witness stand and the videos. Nothing I said or did, nothing Ms. Rose says or does are facts and evidence, just the witnesses. Next, I do want to point out, I'm sorry, I did neglect to do one thing. The other prong I have to prove in instruction number 6 is that this happened in Tumwater, Washington. All the witnesses testified that this happened in Tumwater, Washington at the Linwood Avenue, on Linwood Avenue. So the state has proven its case. Instruction number 7 talks about a person's knowledge and knowing. Another way of looking at this instruction is that ignorance of the law or a law does not constitute a defense. Whether Mr. Little thinks what he was doing was unlawful or lawful on the bus doesn't matter. What matters is, did he knowingly engage in the behavior he engaged in? And it's very clear from the video, and it's very clear from his testimony. He knew exactly what he was doing when he refused to get off that bus. He knowingly engaged in that behavior. He acted intentionally. Again, I would point out, he was not going to get off that bus unless it was on his terms and his terms only, and he wasn't willing to compromise. I'll get off if you give me a courtesy ride. Is that your bike? Yeah. I can't take the bike. It won't fit in the car. Well, then I'm not getting off. And he goes back to his seat. And then he refuses to get off when law enforcement tells him to get off. For 5 minutes or nearly 5 minutes, they talk to him, try to get him off. It's his way or the highway. Again, I would ask that you consider all of the evidence and focus on instruction number 6. And when you're done deliberating, find the defendant guilty.
Wow. Used only 9 minutes.
Thank you, Mr. Thompson. Ms. Rowe, you have 20 minutes.
Your Honor, if I may, I'm going to do my closing from the desk because I have too much stuff that I need to reference.
You may.
Can you see her over the podium?
Well, good afternoon once again, ladies and gentlemen of the jury. In order for a bus driver to order someone off their bus, they need to have specific conduct that occurred that supports that would give them the authority to order someone off the bus.
Objection, Your Honor. Facts not in evidence.
I'm just going to remind the jury that the lawyer's remark statements aren't the law or evidence. Those are contained in my laws contained in my instruction. Evidence is what you heard in testimony. Ms. Rowe, you may continue.
As we heard from Mr. Rose, the supervisor, neither the bus driver nor the supervisor, and I would even go as far as to argue, nor law enforcement has the right to order someone off a bus without reason.
She might win it here if she can pull this
This
together.
was supported by Mr. Rose's testimony. No, we can't just get on the bus and order someone off without assessing the situation. Unfortunately, he did not assess the situation either thoroughly nor correctly. It was his conclusion that the driver was distraught. However, we heard the driver calling for the supervisor on the recording. That driver did not sound distraught. That driver was not speaking in raised voices, not when she called the dispatch. She didn't even sound as if she was talking fast. The driver called dispatch to request the supervisor at Mr. Little's request.
We have a pull up.
There's a big
guilt.
difference there. Calling on your own because you're reporting harassment behavior. Calling on your own because you're reporting aggressive behavior, or calling at the request of a client that you have ordered off a bus who has not committed any conduct that warranted an order to get off the bus. I'm hoping you will listen to the recordings, because what you won't hear is the bus driver saying, Mr. Little is speaking in aggressive tones and it's scaring me. What you won't hear is the bus driver reporting, Mr. Little was harassing me and it distracted me from being able to carry out my duties. There was no allegations of those behaviors even alleged. The bus driver called dispatch to request a supervisor at Mr. Little's request because he had informed her she had no right to order him off a bus when he had done nothing wrong. It's unfortunate that the supervisor appeared to the scene and concluded that the bus driver was distraught. It's unfortunate that the supervisor responded to the incident and he didn't even do a thorough investigation as to what specific conduct Mr. Little had engaged in before he was called that warranted a bus driver ordering off a passenger off the bus. There has been no evidence presented that would show any unlawful conduct that Mr. Little engaged in before both the supervisor and law enforcement was called. I find it very interesting that the state made sure to reiterate twice in its closing that, let's be clear,
Thrice?
The unlawful conduct, in fact, let me state it in his own words. The state just indicated that it wanted to be clear that interaction between the driver and Mr. Little is not what constituted the crime charged. I would argue that the state has got it wrong. It's the conduct or the behaviors that Mr. Little engaged in before anyone was called that needed to support the bus driver's first and second order to get off the bus. The reason I would argue that actually the focus is backhandedly on the interaction between the driver and Mr. Little, it's further flushed out in the jury instruction number 6. I'd like to review that with you. Before law enforcement arrived, Mr. Little had not engaged in any conduct that obstructed the flow of traffic or the transit bus. He had not engaged in any conduct that hindered or prevented access to the other riders. He had not engaged in any conduct before the supervisor and law enforcement were called that unlawfully interfered with others' use of the public transportation service. The bus was stopped at a break when the bus driver initially asked him about the battery. Mr. Little, whether he was annoyed or not with having to answer that question, answered that question, and the bus was still stopped and had not taken off. So that first bit of contact between the two did not interfere or impede or unnecessarily keep the bus driver there at the break for longer than she chose to. Next, the focus is on whether Mr. Little engaged in other conduct that was inconsistent with the intended use and purpose of the transit bus. He did no such action. He had done nothing. In fact, he was himself availing himself of the use and enjoyment of riding the bus.
I've never really enjoyed riding the bus.
If you look at the law, it indicates that in order for the state or for you to find Mr. Little was guilty of unlawful conduct, you have to find that he knowingly obstructed or impeded the flow of the transit. We've already discussed that. Whether he hindered or prevented the bus driver in her duties, we've already discussed that. Or whether he engaged in loud, raucous, unruly, harmful, or harassing behavior before law enforcement or the supervisor was called. He did not. At the end, I want to bring your attention to the end of that section of your jury instruction, because it indicates that he needed to engage in some of these conducts in order for the bus driver to even have a legal reason to order him off the bus. And that once either the transit authority or law enforcement lawfully commanded him to get off the bus, but first it requires in and of itself for the supervisor, both the supervisor and law enforcement, to first order or ask or command him to cease such conduct. What is that conduct this statute is referring to? The conduct that had happened on the bus that occurred before state actors were called. You may have wondered why I asked both Mr. Rose and Mr. Little. At any time, did either law enforcement or the transit authority ask you to cease any conduct? No, they didn't. They didn't follow the rules. And them not following the rules is what violated Mr. Little's right to the full enjoyment of his bus ride. So I would argue that the focus is the only way the bus driver could have given a lawful command was after Mr. Little had engaged in some prohibited conduct. I elicited testimony from the state's witness. It is not illegal to address a bus driver. It might be annoying to a bus driver, but bus drivers are well trained on how to ignore an annoyance. What happened this day was Mr. Little caught this bus driver in what I would characterize as a pissy mood. She was in a mood before she even asked Mr. Little about the battery. And when he answered her, because he was snippy in return, she unlawfully just threw out a veiled threat. Or it in fact basically did what the state just is arguing that Mr. Little did. It was her way or the highway. You don't like the answer, my question? You can get off my bus. She's not allowed to do that. That's unlawful. When the supervisor came to investigate the incident, you can see yourself, as we've all viewed, he did not give Mr. Little a chance to explain. He did not give Mr. Little the opportunity to educate him on what needed to happen before he was able to give a lawful order to get off the bus. Nothing supported any lawful order that had happened prior, supported any lawful order by either the bus driver or the supervisor to order Mr. Little off the bus. I found that it was very interesting when Mr. Rose indicated that there are times when an operator, meaning the bus driver, can escalate the situation. That's what happened today. This bus driver was having a bad day, and she let Mr. Little know it the first time he seemed annoyed that she asked him about a box that was clearly not a battery on the bike. But he acquiesced and answered her. The bus driver had no further problems until it appeared to Mr. Little that she closed the doors without allowing the last passenger to fully exit the bus. It was not unlawful for him to notify the bus driver, hey, you closed the lady's arm in the bus, in the door. But it was clear what mood she was in when she responded to that. She didn't say anything about it, and neither should you. In fact, when she called dispatch, she told dispatch that Mr. Little had accused her of closing the doors basically too early. That happened. What she didn't do is say, Mr. Little cussed me out. Mr. Little threatened me. She simply said, basically, I'm annoyed and I want him off my bus because he's invoking some civil rights. That's what happened. And he had every legal right to refuse to get off the bus because before the supervisors and law enforcement arrived, he had not engaged in any prohibited conduct that warranted and would have supported a lawful order to get off the bus. In voir dire, I asked the jury pool, how many believe that the officers always get it right?
Here's your 2-minute warning.
And all of them, including yourselves, acknowledge officers don't always get it right. Well, this incident, the supervisor got it wrong and law enforcement got it wrong. Mr. Little had done nothing wrong. And that is why he was so adamant in his refusal to get off the bus. The supervisor also indicated he could have offered, since there had been no specific conduct, that he specifically requested Mr. Little to cease, as the statute and the law requires. Because of that, there was no conduct. He could have easily done what he asked, testified that he could have done. He could have said, Mr. Little, this bus driver would rather you not speak to her. Then he would have satisfied the policies and procedures that were required before ordering someone off the bus. No one ever did. Unfortunately, both the bus driver, the supervisor, and unfortunately, even the responding law enforcement never followed the statute's requirement, and that is to first request that the bus rider cease such conduct. Because they didn't ask him to cease any conduct, because really there wasn't any conduct that he needed to cease, as he testified himself, it was right before his stop. There was no further communication between he and the bus driver. That's what made the order to get off the bus unlawful by both the supervisor and law enforcement. And it's ultimately the reason why he was arrested.
Ms. Rowe, you have one additional minute, just to let you know when your time's almost up.
I'm asking that you, as jurors, glean over the evidence. I'd ask that you rewatch the video. And I ask you to determine that Mr. Little's communication with the bus driver was in no way unlawful, and that he is innocent of unlawful bus conduct. Thank you.
Members of the jury, the state carries the burden of proof in these cases. As such, they're entitled to a rebuttal. And so, Mr. Thompson, you have 7 minutes.
Thank you, Your Honor. What you won't find in your jury instructions is some sort of policy and procedure laws, some statute about what lawful bus riding rights exist, because they're not part of this case. This is not a civil rights case. It's not a civil rights lawsuit. This is not what Ms. Rowe is trying to make it sound like. This case is about your jury instructions and the facts that came out in trial. Okay. Now, this is going to sound a little backwards, but the ceasing that Ms. Rowe keeps talking about, she's talking about Mr. Little's interaction with the bus driver. And I, again, will stress to you, that is not what the state is alleging is the crime here. Mr. Little refused to get off the bus. The supervisor and law enforcement asked him to cease his sitting and refusing to comply. That's the conduct. Refusing to get off the bus is the conduct that he was asked to cease doing. But separately from this, he impeded the transit. He's not allowed to do that. He delayed this bus 15 minutes. Now, again, defense has, and I told you in my first closing that defense was going to talk about the interactions between the bus driver and Mr. Little. Again, that is not what constitutes the crime here. Now, Mr. Rose on the stand reiterated some of the rules, not all. I mean, to be fair, I'm sure there's a laundry list of rules that people have to follow on the bus. But he gave you an example of one, which was sleeping, right? And we may not necessarily intuitively think of why a rule exists or the reason for that rule existing. To be frank, I never even occurred to me why sleeping on a bus might be problematic. But an emergency slam on the brakes with his explanation, person goes flying, could hurt himself, hurt another passenger. Absolutely made sense to me in that context, right? Another rule he did say when asked was, do you have to follow the directions of a bus driver and transit employees? He said, yes. Directions of the bus driver and transit employees. Mr. Little was ordered, or not even ordered, he was asked. You get off the bus, take the next one. Solves the whole problem, right? Bus driver feels uncomfortable around you. You guys aren't meshing. Something's going on here. Take the next bus. He refused. So the supervisor again asked him to cease his behavior of refusing. Get off the bus. Law enforcement needs to come. Hey man, you got to get off the bus. He again refuses to cease that behavior of refusing. You don't get to refuse reasonable orders here. You don't get to refuse. He's impeding the flow of the transit. Now, what you won't hear in your jury instruction or see in your jury instructions, really any of the things that Ms. Rowe called law or policies, procedures, there's nothing in your jury instruction number 6 that says prior to a transit employee ordering someone off a bus, they must have a lawful basis to do so. That doesn't exist. There's nothing in your jury instructions about what transit employees can and can't do because they're not on trial here. Ms. Rowe spent a lot of time trying to make this a trial about how rude and inconsiderate the bus driver was to Mr. Little. And I'm not in a position, nor would I be in a position to defend any of her behavior. Was she short-tempered? That's up for you. That's for you guys to decide. I would argue that it's not relevant. The question is, did Mr. Little impede the transit vehicle? And the answer is yes. He refused to get off the bus for 15, 20 minutes. So much so that he impeded that bus so much so that a bus that runs every 30 minutes, while Mr. Rose was still writing out his one-page statement, the next number 12 came by. That's how long Mr. Little impeded that bus.
Takes me an hour.
While he's writing a one-page statement, the next bus was already there. Don't let defense confuse the issue here. Don't let defense make it seem like the transit employees had to follow some magical procedure that doesn't exist before asking Mr. Little to get off. Back in jury selection, I asked you about, I gave a scenario about planes. I gave a scenario about me being in a government building, sticking my phone in people's faces. And security comes up to me and says something along the lines of like, you can't do that right here. If you want to come back and film later, sure.
We watched that case here in this court.
And he's in a public place. Yeah, sure. He can ride the bus. They weren't trying to deny him his right to ride a bus or his ability to ride a bus. They wanted to separate him from the bus driver. He refused, not because of some civil rights thing. That's something he's latched on to because it sounds nice and fancy. He was angry at the way the bus driver talked to him. He was angry that the young supervisor was talking to him in the way he found offensive. And he dug his heels in and he wasn't going to change. We know he felt that way because he started complaining about young college kids and then he kind of trails off. His behavior and demeanor, you guys should consider when looking at the video here. Looking at his demeanor here. Look at his motivation for presenting things in a certain way. Your jury instructions do tell you to consider those. They don't tell you to consider what Ms. Rowe was talking about, is some sort of magical policy and procedure or lawful reason this or lawful. None of that is true because it's not in your jury instructions. It's not in the evidence.
Mr. Thompson, you have 1 minute.
Thank you, Your Honor. Again,
they both got bonus minutes.
That on or about June 10th, 2024, which the state demonstrated with all the witnesses, the defendant, while on or in a transit vehicle, he was in a bus, knowingly obstructed or impeded the flow of a transit vehicle. He delayed that bus by 20 minutes, and he did so knowingly. Unreasonably disturbed others by engaging in loud, raucous, unruly, harmful, or harassing behavior. Again, I would say that behavior ties more towards the bus driver, but that's not what this said. I was alleging. Again, the state is the one alleging the incident. Ms. Rowe doesn't get to decide what part of this is the crime.
This is personal with him and Ms. Rowe.
If you hear about his, or if you would listen to his conversation with Mr. Rose versus his testimony here, he has no reason to yell. Not at least the way he presented. He was talking in a relatively voice. In fact, at the beginning of this, he was talking so quietly that some people might have had difficulty hearing his initial testimony. He gets animated, he yells, and his voice goes up. He got animated, and he was yelling. But more importantly, so I would say impeding the flow of transit vehicle. But more importantly, he refused to obey the lawful commands of the agent of the transit authority, the bus driver and or law enforcement. The bus driver and the cops told him to get off, cease his refusals to comply, and he refused. We ask that you find the defendant guilty.
Members of the jury, the 6 of you, except for you, sir, in the back, can be taken back into the jury room where you begin your deliberations. Juror number 7, I'm just going to have you wait right here. Ashley's going to come by and get your phone number, your contact information. You're still part of the jury. And so I've had the experience before where people start deliberating and then an emergency arises or someone gets sick and then the alternate has to get called in and then you have to start all over again. And so we'll take your phone number. We'll keep you informed. If a verdict is reached, we'll let you know. And then, but for right now, I'm going to have you stay while the other 6 go back and begin your deliberations.
Well, unceremoniously, number 7 is like, not you, sir. You stay right here. You don't get to deliberate.
Yeah, you can go back there and get that. Yes, of course.
So now we need the stopwatch again on deliberation. Let's see. Let's go back to stopwatch and start deliberation time. There we go. It's gonna count up here. This is can we have a new poll? How long will the jury deliberate?
Mr. Little be excused to use the bathroom.
Yes.
We get a potty break. What's the new poll you want? Do you want on guilt or innocence?
Don't stay here.
Because the way it came back previously, we had 66% say guilty, 33% say not guilty. You want a new poll on guilt?
And you're on.
I've never done 2 polls on that before.
Are both of those pieces of evidence going to the jury?
What was it? Which pieces?
Defense exhibit 1 wasn't admitted.
The report, the written report, if that's the other one, that's not. Okay. That was not admitted. Okay. But the video is.
Okay. The video was admitted.
Yes. What was that? The police, the written report?
Let's see.
Yeah, that's not admitted. That was not.
And with that, we're into that one. We're waiting for the verdict now. So let me run back to where I belong. Hang on 1 second. USK DVE flying key, run to A. There we go. See, I told you I know what all these buttons do. Okay, new question. How will the jury vote? Okay, hopefully I spelled everything. It's been a long day. Hopefully I spelled everything right here. They're not hard words, so. How will the jury vote? Guilty, not guilty, or hung jury? There are only 6 people. 6 people to agree. So we are going to, let's see. I think we're done with this one. Stop and go back. Oh, that's funny. I went to jump to the channel, to the live feed, and it looks like Law Talk with Mike is streaming the same channel, the same court case. We both picked up the same one. Love Law Talk with Mike. He finds some great funny cases as well. Okay, so we need Thurston County Court, District 4. There we go. So we'll keep checking for a live feed from there, and if anyone sees one as well, let me know. I'm sorry. It has been a long day. Oh my goodness, it's been a long day. As you can see, when we started the day, the sun was shining in the studio, and now it is so dark that I feel like I need to turn on more lights. Except for this one. This one's too bright. There we go. Kick that little guard up a little higher. But we have a new ring up for the verdict. New poll. Would you have gotten off the bus? Some moments that stood out to me on this trial. Clearly, I think he has a civil suit, or at least there's some merit enough that this should go and be heard before a judge on his claims that his rights were violated, because I think they were. But man, the judge rules the courtroom, the pilot rules on the plane, and the bus driver rules on the bus. It's one of those things where you might disagree with the officer who gives you the ticket, but the side of the road is not the place to argue. You take it to court and get it sorted out there. And so, yeah, it's I do hope. Well, my heart feels bad for him. First of all, he's homeless, okay, and the challenges that that people who are homeless deal with are huge. Just the things that I take for granted. I go run upstairs and take a shower. He has a 5-mile bus ride to and from downtown. Life is harder. Life is harder for sure. Things that are just a given in my life are not in his, and that could include such basic things as food and shelter. So I feel for him there. The way the law is written, the law is irrespective of person. It doesn't say, well, this applies to homeless people or not to to others or vice versa. So I think for sure the law is written that he's guilty. If he is convicted of this is a misdemeanor. This is not going to be jail time. This is going to be a fine at best, and maybe probation. And I know, unless I'm super surprised, but I don't think they're going to, put him in jail over this. The civil suit, on the other hand, would not just be, we're going to refund the amount of a bus fare, which I think is free in these buses. I think the route he was on didn't cost him anything. But if they do find that his civil rights are violated, that's where lots of zeros and commas get involved. And it seems strange that the city would pick this fight. Now, him losing this criminal suit, this criminal case, might also hurt his civil suit, where you can say he was convicted of unlawful transit conduct. That might hurt his civil suit. But at the same time, it could also add a little multiplier. That's just one more way his rights were trampled on when he was convicted wrongfully of this. So it's going to be interesting. I don't know. I don't know if he has needs like that. If he prefers to live this way, we don't know. We don't know that at all. We just know that he stays at a place where he says, in the bushes where I sleep, where I stay. He doesn't refer to his home that way. So let's see. No verdict yet, and I'm honestly surprised. I think this will be a quick one. Either way it goes, I think it would be pretty quick. It could be really tempting for a jury member to see. I feel so bad for the guy. He's like, I just want to get home. I'm homeless. I've got a broken bike. I just want to get home. And for them to say, oh, you can't kick this guy when he's down. That is not the law. As a matter of fact, the judge read the instructions to them and said, you cannot decide this based on, oh, it pulls on my heartstrings. You can't do that. But, yeah, feelings are not facts. You have to follow the law. He's a retired factory worker. It sounds like he has some military service. He says he was in the Ukraine, front lines in the Ukraine. I'm not sure which side that would be on, or who. Let's see. You might have to wait till the morning to get the verdict. I will stay up and watch and hit refresh a million times and make Josh do it as well, because he's the one that told us about this case. So, I don't need no stinking law. Funny part. Sorry, that was a Freudian slip. A funny part in this trial was when he was referring to his attorney, Ms. Rowe. He says, my attorney, what's your name again? What's your name? She's like, Ms. Rowe. Oh yeah, Ms. Rowe. He has had a couple attorneys. He wanted to sort of represent himself, but yeah, De Niro called out De Niro. Says the supervisor was like a De Niro voice. You want to talk to me? You want to talk to me? I can't do De Niro at all, obviously. This is why I'm not an actor or an impersonator. Gloria Rowe is the defense attorney. We've seen her. I actually like her. She has a very deliberate style that has grown on me over the years. Katie Rose, yes, we're still here. I'm still stuck on the state isn't arguing the interaction between Little and the bus driver is the issue, while saying the bus driver's directive is the issue. Yeah, you can't parse it so neatly like they would like to. They would like to separate the fact that the bus driver was wrong about the battery, that there wasn't an issue, that he wasn't breaking any rules. They'd like to separate that from the fact that he was told to get off the bus and didn't. Now, I think what the issue was, and this is why I think he's going to lose this case and be found guilty, is that when the supervisor showed up and did his investigation, as poor an investigation as it was, he made observations and made a ruling. And he has the right to do that, and he has the authority to do that. And it might have been wrong, but I believe the command to get off the bus was lawful. At that point, that's when you take it to court. And you say, okay, I'll get off the bus, but this is wrong. I'm going to sue you. I'm going to sue, everyone that knows you and everyone you've ever worked for. Whatever your threat is, you can do that. But I think that at that point, the supervisor who had that authority to enforce, to come down and say, okay, this is what needs to happen. I think that was a lawful command. So we are on verdict watch once again, second time in one day, still no verdicts yet. Let's see. So we're ending the poll really quickly. The numbers have changed a little bit. Let's see. A couple percentage of the guilty group and a couple percentage of the not guilty group have moved over to the hung jury. Other than that, it's virtually the same. If you eliminated hung jury, I think the proportions are virtually the same. So still about 2/3 of us say guilty, 1/3 say not guilty. I wonder how long the jury will take. I don't know. Let's see, courtroom 4. Let me just sort of pull it up on a different feed. This one. Okay. This one will show me when they're live before it actually goes live. Does that make sense? It's a secret. Maybe this is how you guys win the internet so quickly. But if you're on a YouTube page that has like I'm on the live page for Thurston County District 4 courtroom. And when you refresh on that screen, their thumbnail will say live at the bottom before the actual thumbnail. Like their profile picture will say live before the thumbnail shows up. Did we get a verdict back on Collin yet? No, we did not. They deliberated for about an hour or 4 hours and 40 minutes today and did not reach a verdict. So they wanted to go home at 4:30. They're going to start again tomorrow at about 8:30 in the morning. And then tomorrow also the Boswell trial is starting. So we're going to be sort of doing double duty on that. Jury's been in deliberations for about 11 minutes. Oh, is that not on the screen? I'm sorry. I show 13 minutes is how long they've been deliberating. But let me get this on the screen really quickly. Super source, box source 1 is going to be 7. And cut. Box source 2 is going to be 4. There we go. Oh, 13 minutes. I need to change that cutoff. Cut the 1 off. There we go. Is that better? Perfect. Sorry, I didn't have that on the screen for you. Good luck suing the government. It's harder than suing a massive corporation. Okay. All right, now have the mouse hovering just right to be able to refresh a million times on that channel. If they watch all these videos, we're looking for midnight for a verdict, says Sinbad. 45 minutes of video. I don't think they're going to watch it again. I think they probably saw everything they needed to see. It's only 4:50 court time. What's the Northwest? You're from that area, I presume. What is the typical ending time? Is it 5 o'clock when they normally wrap up, or 5:30? I can't see this stretching into another day, but at the same time, this is the sort of courthouse. We like to call it like the Holiday Express courtroom because it looks like a hotel lobby. It's the sort of courthouse that might have to shut down at a certain time and not be able to deliberate overnight. 5 or 5:30. So it's got to be quick if we have a verdict. What if they leave us hanging again and don't go live until the verdict is before? If they do, we'll call up the courtroom, as we've done before, and say, hey, you left us hanging. What was the verdict? And they'll tell us. At 5 o'clock, the courtroom turns back into a lobby. The guests in the hotel come through. It gets crazy. Might be tomorrow. Don't say that. Tomorrow is so busy already. Set up a buffet table. That would be great. ASAP Rocky, we have not followed that one. I know it's had some interesting moments there. We're going to be picking up another case that starts tomorrow. The jury just got seated in Tennessee versus Boswell. That's going to be a tough trial. It has to be quick because you're 30 minutes from being on the stream for 6 hours. Why, yes, we are. You're right, 34 minutes. 6 hours is the magic number on YouTube. As a content creator, there's some things you have to do. And sometimes on court cases, whether it's something somebody said in chat, whether it's something that was shown on the screen that the judge says you have to remove or things like that, there can be times where I have to go back and edit a very small part of the video out. And YouTube only allows you to do that if the stream length is 6 hours or less, or I guess you say under 6 hours. And so if I go 6 hours and 1 minute or 1 second, I can no longer make that edit. And if I am ordered to do something, the only recourse is then to take the entire video down. And then people lose a day of court. If they're on the rewatch crew, they're not able to see it. So I do try to keep all the live streams where we have court cases that we're following. I try to keep them 6 hours or less. It also helps if we're in different fights with other channels about content. It's easier to edit things and make changes to comply. There have been times where I've had family members or even witnesses contact me and ask that I take some material down from a court case. And when they ask respectfully and they have a valid reason, I generally comply. I know that does, take something away from those who are on the rewatch crew. But I try to be respectful and work with people, especially knowing that a lot of those people, if they had made that request to the judge in court, it would have been granted and we wouldn't have had that anyway. So, help for the crossword and clue. Ecological portmanteau since 1905, 4 letters. M, what level of crossword puzzle are you doing? Ecological. You know what I'm going to do? I'm gonna jump on X really quickly and go to Grok. What is a 4-letter word for ecological portmanteau? Smog? Smog? Is that's what Grok says. Does smog fit? That's a 4-letter word. Since 1905, that's Industrial Revolution time. Does that work? Did I cheat? Yes, I did. That's cheating. Why did you ask the guy who has the internet in front of him the answer if you didn't want the answer? And no cheating. Who says no cheating? I was using all available information. Yeah, I'm not good on crosswords. Asking chat is cheating. Port, it's a combined word like snert. So smog and fog, that's where it comes from. Okay, still no verdict here. We are going to, if we don't get a verdict here in the next half hour, we are going to wrap things up, and I will bring you the verdict tomorrow morning, probably early before court starts. Nurse Kate says, watch you for a long time. So glad to be part of this wonderful community. You do an amazing job covering trials. Nurse Kate, thank you very much. Thanks for being a lurker, and thanks for coming out of the shadows and saying hi. Welcome. I love it. Spork equals spoon and fork. Is that an that's not an ecological. That's a utensological. Portmanteau. I have no idea what those words mean. Oh, man. Red pen, help me. Bail me out here. Portmanteau? Portmanteau? It seems like a French word. Why since 1905? I think it was the Industrial Revolution around that time, right? That would have brought on the fog and the smog. Portmanteau. New trial tomorrow. Yes, new trial plus possibly 2 verdict watches. Yeah, I say all the words wrong. Apparently I say else wrong as well. Like, what else are we going to do? I don't know there's another way to say it. If you stay long enough, I'll celebrate my 14 months early. We're going to stay for no more than about 25 minutes. So we are about to get a verdict here, I think. L's? What L's? Else. Else. How is that different? What L's are you going to do? That's like L apostrophe S, L's, or that would be L's. You put a T in Elsie. Say Elsie. Else. What else? Barely. I have a tiny. Rona says, love you, Ari. I know I can be annoying, frustrating, argumentative, but it's all educationalified. So, thank you, Rona. I appreciate it. Oh, man. You sound like you have a T on the end. I have a T in the middle. Else. Okay. I'm going to try to fix that one because I can acknowledge that I'm adding a syllable that just is not there. Try saying the name Elsa and then remove the ah sound. Now I question my whole vocabulary. I had no idea that I had an accent. Honestly, that I was pronouncing things wrong. Just kidding. That was for you, Red Pen. Until I started live streaming. And then people just saying, say that word again. I'm like, which one? They're like, the one that's spelled Collor. I'm like, Kohler. And everyone thought it was hilarious. I still cannot tell the difference. But the minute you end a stream, the verdict will come in. If it does, here's what I can tell you. I will record it. We will watch it together tomorrow morning. So if we have to go to bed before the verdict comes in, we're gonna try to get it anyway. Have you ever heard Rob on Lawn Lumber after a 5-hour FNF? Don't sweat your pronunciation. Well, was any adult beverages involved? I don't have that excuse. It's a crayon. It's not a crayon. That would be CRAN. It's a crayon. They're made by a company called Crayola. Instinctively Correct says, wait, I'm just tuning in and you're still live. What? Miss you all, RA, and all my fellow addicts. New job doesn't let me watch live. Oh, replay crew now. Instinctively Correct, welcome. We've had a long day, but it's been crazy. It's been crazy and it's been good. But congratulations on the 21 months. Instinctively Correct. That is awesome. Thank you. And thanks for leading the replay crew for so long. How about a specific fishing tackle? Like a hook? A lure. A lure or a lure. That's what you're getting at. I call it a lure. Okay, I'm watching two things at once, trying to watch to make sure we get the verdict when it happens, because it could be very, very quick. It's caramel, not caramel. That middle A was there on accident. Please say allure. 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 Yeah, I do sort of. I can hear my accent in that one. These are all words I didn't know I was saying wrong. My arm is cramping from holding that position, the mouse exactly in the right place and refreshing. Tour, like a tour bus. Is this just like a pronunciation stream? Oh man. Here's where we are in a couple trials. In the Collin Griffith trial, we are in verdict watch. The jury has deliberated for 4 hours and 40 minutes. They went home at 4:30 in the afternoon today, and they will be back at 8:30 in the morning to continue their deliberations. They've asked one question so far, and that was, can we have the transcript for the 2 neighbors who testified that they saw the altercation between Collin and his mom outside Grandma's house? The answer was no, you can't. But if you give a limited request, we may, at the court's discretion, read back some of what happened, and they have not yet provided that limited request. So that's there. We've also been up in Thurston County, Washington, which is where we are right now, waiting for a verdict to come back in Mr. Little's case, which Mr. Ken Little is charged with unlawful transit conduct. That's basically being a bad person on a bus. And I don't know. He's homeless. He was transporting his bike. It all started because, well, he might just be an aggressive person, or his personality, doesn't handle it well. But it started the way the bus driver challenged the ammo can he had attached to his bike as a storage locker on the bike. And it just spiraled out of control, ended up getting a supervisor called, getting the police called. He got arrested. And now here we are in Thurston County, Washington, in court, arguing over somebody getting off a bus. It's a wild case. It's been pretty interesting. Then tomorrow we have in Tennessee, we have the Boswell trial. And this is a trial where we've got a mother accused of murdering her child, her infant. And it's going to be a hard case. It's a huge one. And it's one I think that deserves coverage. There was weeks of search involved, and there's lots of questions about why was it not reported for 2 months? Why did it go so long before we knew that there was a baby that was missing? And we're gonna dig into that one as we watch that. But also I understand if some of you choose that's not the best one to watch, because it is difficult. It does have some very tough fact patterns. We don't do a lot of those cases with children involved, and that's for a reason. It's a heartbreaking case. It is. But let's see, Letitia Stout, take 2. I don't know how bad on her side it would be, but yeah, it's going to be. It's going to be rough. So that's our plan there. Still not live in Thurston. Yeah. She's the new Casey Anthony. I can see the resemblance. Let's see. Okay, we have less than about 15 minutes, and we have to turn into a pumpkin or shut down the stream. So it's been a fun day. We've had a lot of new people join us, and thank you. Welcome to all those who are new and here for the first time, who click the subscribe button. Hey, it's scary doing that sometimes. What am I committing to have on my YouTube feed? But I appreciate you doing it, and hopefully we can earn your repeated visits. You're here now. You're a member. You're one of us. You can never leave. Just if you do come watch court with us, please know that you are among friends. We might not always agree on everything. As a matter of fact, I like it better when we don't always agree, because it helps me learn and challenge my own opinions. We just ask that all the conversation be respectful, that we not call names, and try to focus at the legal issues at hand instead of maybe some of the distractions. We do have fun now and then. We try not to do it at the expense of someone else. And I, have, area to improve in that section as well. So, if that's what you would like in watching court, all I can commit to is trying to provide the very best audio and video in a court watching experience that you could possibly get, and the best community in the world. We have that as well. So please do click the subscribe button, ring the bell, and come back and join us as we watch court together. The Boswell case, yes, they have seated a jury, and Lizzie, they're sequestered. which means like the last sequester trial we watched, we had a jury that said we want to work on the weekends, and they did. So we'll be working on Saturday, not Sunday, but just Saturday. We'll be holding court on Saturday through the trial. So it's going to be long weeks. We will get a weekend stream. I don't know when I'm going to work on my bathroom remodel. It might have to be late at night, but that's going to go how it does, because the jury can't go home until this is over, and it could be a month. It could be a month. Let's see. And we don't do many cases with kids. We've done a couple, and we space them out so as to not be frequent. We try to just do regular murder trials, but this is one that I feel is important to cover. Just like with Letitia Stout. How far along is your bathroom remodel? About the same amount it was last week. I put in one of the floorboards. It's been construction adhesive and screwed down to the joists. It's in place. It's not coming up, or else I have to rip it off the floor. But we've got that in place. I've done a lot of the plumbing. We've built the connections to replumb the new sink. I've got all the parts to replumb the new shower, and to run the new water lines for both. Yeah, so that's where we're at, because once the new floor is in, it's going to be really hard to work underneath there, because it's harder to crawl under the house and do the work. It's easier to do it when it's all open from above. So we're going to get that done. As soon as it's done, we'll put the floor in, and then we can really speed things up. I can lay the new floor in. We can put the new shower in. The new toilet gets seated. The sink, the walls get built. Everything happens from there. It goes fast once that's done. Do you have a background in construction? No, I don't even have a background in deconstruction. How do I do it all by myself? Some people say trial and error. It's mostly just error. I mean, being truthful, I just make mistake after mistake, and I learn from it and try to not do it the next time. And I have some friends that do construction. Like last night, I went late. A friend of mine who actually helped me build my Airbnb. He had this is a funny story. He had a tool chest, one of those roll-up tool chests with the metal drawers that slide out, that was locked, and he could not find the keys anywhere. Now, I happen to have experience with lock picking. I've never been a locksmith. I just know how to pick locks. And one of the things I researched when we were looking for a place to move when I moved to North Carolina is the laws on lock picks, because I do participate in something called lock sport, which is the game of picking locks legally. And there are some very fine rules. I like to say there's a fine line between fun and felony when it comes to lock sport. But I can pick locks, and I really love to do it. It's a challenge. I like to be able to defeat a lock. Anyway, so he said, "Can you please come? I've got this roll-up tool kit with tools in it and everything, and I can't get it open." So it took me about 45 seconds to pick the lock, and it's the first time I've ever picked a lock that has the keys that have bumps on both sides. It's the first time I've ever done one of those. So I picked a double-sided key with the dual bitting in 45 seconds, which was pretty good. And I ended up picking it about 4 times because we spun it the wrong direction. I had to reset. It was fun. So I picked it several times, got it open, and anyway, I was over helping him, and then helped him with some computer stuff. I have a friend like that. He's one of the friends that I call and say, "Sean, bail me out here. I'll send a picture. This is where I'm at. What do I need to do?" And he'll give me some advice as well on construction. So, all right. It's a long story. I pick locks. You should do a video of that sometime. It's weird that a lot of police don't know the laws when it comes to lock picks. I'm scared to go somewhere and pick locks for fun, because a lot of people think that a lock pick by definition is a burglary tool, and that you can be arrested just for having it. Even police officers that I've talked to feel that's the law, even though in North Carolina, as long as I'm not charging them for my lock picking service, I don't need a license. And as long as I'm not committing a crime at any time, I have permission from the owner to do it, I can pick a lock. But I'm nervous. I don't want to get, busted. I don't want my case about lockpicks to be the next one. What a unique bartering skill. Yes, I can pick your locks if you'll help me with construction. All right. Locks are, we live right now? We're live. We're live, Kathy. We have not gone to bed yet. We're still up. We're waiting for a verdict in this little tiny case out of Thurston County, Washington about a bus. But locks keep people honest. They keep honest people honest. They don't keep criminals out. A criminal can probably open your lock faster than you can with a key, and they'll do it without one. So locks keep honest people honest. I have a whole collection of locks that I can pick. There was a time when I've told you about failed business plans that I've had. I failed many businesses. That's ideas I wanted to start up. I've invested a lot of money, and then it just did not go anywhere, and I lost my money. One of those failed businesses was selling lock picks, and I wanted to get to where I sold a lock picking game, a literal game, like you go down to Walmart and like, hey, let's play Risk or Monopoly or lock picking. I wanted one of those, and I was designing it. I had this prototype. I was finding sources for a bunch of different styles of locks, and the idea was you would open, all the locks would come with keys, and you would lock them together in a chain, and you would have 2 of every kind of lock. And you are head to head against another player, and you start and you hold this chain of locks, and as you pick each lock, you take it off and put it on the other person's chain, and the person who runs out of the chain first wins. So you're racing the other person having to pick these locks. Great idea, right? Everyone's like, hey, I'd play that. Future's like, I'd do that. Well, guess what? It is against the law in the United States to mail a lock picking set to someone who is not a certified locksmith. Yeah, it's against the law. You can't FedEx it. You can't UPS it. You can't send it on USPS. Suddenly my idea became I can deliver the lockpicks in person, but not if you live in states like Tennessee, where it's against the law to possess lockpicks unless you are a certified locksmith. And suddenly I realized that the laws in every different state basically made it impossible to play my game. So no one gets to play unless they, meet me in person, and I'll bring the locks. And I've done it for youth groups where they have meetings like, hey, who wants to do some lock picking? And some parents are like, don't show my kid that. Don't teach them that. They're not criminals. I'm like, I didn't say they were, but I have taught kids how to pick locks, and you'd be amazed when it clicks. The feeling you get when you're fighting this little lock trying to make it open, and suddenly it just pops open without a key, and you're like, I did that. It's awesome. It's really awesome. I'm just high on court. It's been a long day. I'm super tired. But you know what? We've been going for 5 hours and 50 minutes in the second stream, which means we need to wrap this one up. I'll keep watching for the verdict. We'll let you know what happens tomorrow, or we'll call the court and find out if they don't air it, because they've done that before too. So that's how we have to wrap it up today. What a day. What a day. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning, hopefully with 2 verdicts and a new case to watch. It's gonna be crazy. This is the Super Bowl of true crime, as so many cases are happening at the same time. Cases that we've been following for a long time, like Karen Reed, are still ongoing. Cases that we're really looking forward to, like Corey Richens, are developing. We've got things happening in the Idaho 4 case. We've got so many. I'm pretty sure there's some developments on the Maya verdict or case as well. So lots of things to do. No court watcher should be bored this time of year. And hopefully we can bring you all the great stuff and talk about it here like we do among friends. Send us to Megan Fox. Does Megan Fox let me send to her? Let me check. looks like she's talking about what the hails. So we'll do that. We'll portal over to the Megan Fox. When you get there, do click the like button, even if you're not planning to stay. It's the polite thing to do. Say hi, you are from us, and wish you the best. You guys have a great night. We'll see everybody in the morning. Portal to Megan Fox. See you guys. Bye.